Dude, are you growing a mustache?
You're all set to begin, Jake.
Leave me alone. All right. All right. I'll call to order the Zoning Board of Appeals meeting for Wednesday, February 26, 2025 at 7 p.m. To all persons interested in or affected by the action of the Zoning Board of Appeals, you're hereby notified pursuant to Section 11 of Chapter 48 of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that a public hearing on the following appeals will be held. The Zoning Board of Appeals public hearing will be held by remote participation methods. Public access to this meeting shall be provided in the following manner. The meeting will be televised live via Xfinity Channel 8 or High Definition Channel 1072. It may also be accessed via the Government Access Channel live stream on the Town of Barnstable's website, which is http://streaming85.townofbarnstable.us/cablecast public site/watch/1 channel =1. Real-time access to the Zoning Board of Appeals meeting is available by utilizing the Zoom link or telephone number and meeting ID provided. Public comment can be addressed to the Zoning Board of Appeals by utilizing the Zoom link or telephone number and meeting ID. You can join the meeting by using the Zoom link https://townofbarnstable-us.zoom.us/j/872-003-17826 or calling 888-475-4499 and entering the meeting ID 872-0031-7826. Applicants and representatives and individuals required or entitled to appear before the Zoning Board of Appeals may appear remotely, may participate through accessing the link and telephone number provided. Documentary exhibits and or visual presentations should be submitted in advance of the meeting to anna.brigham@town.barnstable.ma.us so that they may be displayed for remote public access viewing. Copies of the applications are available for review by calling 508-862-4682 or emailing anna.brigham@town.barnstable.ma.us. I will call the meeting to order with introduction of board members. Herb Bodenseek.
Present.
Paul Pinard. Paul, you're muted.
Upright, Paul.
Not sure where that noise is coming from.
I think it's Rodney, maybe. Oh, Rodney, you got background noise going on there?
Just a neighbor's dog barking. Can you hear that?
Oh, sorry. It looked like your screen was lit up because there was noise coming from, I don't know. Sorry. Nope, I can't hear that.
Paul, we haven't heard from you, so work on your unmute. Mark Hanson.
Present.
Aaron Webb.
Present.
Larry Hurwitz.
Present.
Manny Alves.
Present.
Rodney Tavano.
Present.
And Natalie Pittenger is absent, and I am Jacob Dewey. Paula, Paul went away. Paul has left the meeting temporarily. All right, notice of recording. This meeting of the Zoning Board of Appeals is being recorded and broadcast on the Town of Barnstable's Government Access Channel in accordance with MGL Chapter 30A, Section 20. I must inquire whether anyone's recording the meeting. If so, please make their presence known. Seeing none. We don't have any minutes today. So our first order of old business is appeal number 2024-050. Tim McNamara, DBA Holistic Health Group, has applied for a special permit pursuant to Section 240-30 Medical Marijuana Overlay District. The applicant proposes to operate a medical marijuana treatment center licensed through a host community agreement with the town council with the purpose of conducting patient dispensary sales. The subject property is located at 120 Airport Road, Hyannis, Mass, as shown in Assessor's Map 294 as parcel 014. It's located in the Industrial IND Zoning District. This is continued from January 22nd, 2025. The members are signed, myself, Herb Bodenseek, Paul Pinard, Mark Hanson, Aaron Webb, who are all present today. Mr. McNamara, is he here?
He might be in the breakout room still. Let me go double check. Sarah's helping out with that.
No worries.
Mr. Chairman, too, it looks like Paul has dropped off, just FYI. I
Yeah.
don't see him on the
Yeah.
screen, so.
Yep. He might be back in the breakout room too. And one other thing on the agenda, we did have draft minutes on the itinerary, whatever you want to call it. We did not have it wasn't listed.
It wasn't listed on the agenda for members, but I believe it was listed on the agenda. But that's okay, no problem. I can just
I
add
didn't-
it to the next.
Yeah, I didn't look at them. Sorry, I was looking at
That's
the
fine.
stuff.
No problem.
I'm sorry to interrupt the meeting real quick. Can I ask Attorney Connolly a quick question? I apologize.
I was just about to chime in. Go ahead, Sarah.
Okay. And I don't know which item you're on, and I sincerely apologize. I have the attorneys for the Wendy's item that represent Wendy's. They wanted to know if they'd be able to participate in the meeting at all or no, and I just told them I would check with you.
Yes, they are able to participate, so you can let them in. And the reason that I had my hand up is I just want to make sure that we have a quorum for the Wendy's, well, for everything, but in particular, I'm concerned about the remand hearing. But I see Paul is back on, so I think we're good.
Yeah, as long as Paul can get his audio sorted before we get to that item, we should be fine. Because we'll have 4 members.
Paul, is your audio working?
Paul, I believe you're unmuted now, but we can't hear you. Oh,
I know that's backwards, but. Oh, he's there. Yeah. Paul, can you hear us?
Yeah,
Oh, there he
yeah.
is. Okay.
Can you hear me?
Yep.
now we can. Yeah.
Now,
Oh, okay. I don't know what's going on, but
we can hear you now, Paul.
okay.
Anna, you didn't hear from Mr. McNamara anything.
No, I
He was-
did not.
okay. And I see David's here, so I assume he's around.
You have to unmute, David.
You're muted, David.
Sorry about that. Yeah, he is definitely supposed to be here. You want me to give him a call real quick?
Yeah, if you want. I know David from our team was looking in the breakout room to see if he was waiting.
Yeah, I didn't see him back there.
Can we push?
All right. I'll give him a call right now.
Okay, we can skip and go to the next one and then come back to it too. All right. So that will put us at new business appeal number 2025-001. Alicia L. Fix, trustee of the 333 Sepuit Road Realty Trust, has applied for a special permit pursuant to section 240-94B, non-conforming use expansion. The applicant proposes to alter a pre-existing non-conforming use by transferring the 470 square foot apartment unit located in the former principal dwelling to a proposed 870 square foot golf cart barn. The subject property is located at 359 Sepuit Road, Ossipee, Mass, as shown on Assessor's Map 095 as parcel 009. It's located in the Residence F1 RF1 zoning district. So sitting on this will be our regular members, myself, Herb, Paul, Mark, and Aaron. Attorney Schultz, I believe I saw you.
Good evening, Chair Dewey and members of the board. For the record, Attorney Michael Schultz on behalf of the applicant Alicia Fix, trustee of 333 Sepuit Road Realty Trust. As noted by the chair in the introduction, the applicant has applied for a special permit to alter a pre-existing non-conforming use by transferring it from the former principal dwelling to the golf cart barn.
Hi,
The
Sarah.
property.
It's okay.
Property located at 359 Sepuit Road in Osterville was purchased by the applicant in November of 2021. And at that time, it contained 3 dwelling
Yeah,
units.
I talked to her. He's a big loudmouth and he's not allowed to
Whoa,
talk to anybody.
okay.
He can be
Okay,
let on.
can you please-
But his attorney
Okay.
told him that just the two of them will get on?
Dave, can we mute?
Okay,
Can we
good.
mute them?
Hello.
I'm trying. Hold on.
Yeah, all right, thank you. All right, bye-bye.
All set, Chair Dewey?
Yeah, go ahead.
All
Looks like
right.
it's muted now.
The property shown as on Assessor's Map 95, parcel 009, as well as Land Court Plans 5723B and Lot 170, 5725-62, and contains just under 2 acres of land, is situated in the RF1 district, the AP district, and the Resource Protection Overlay District. The subject of the 3 dwelling units at the property has been, as a pre-existing non-conforming use, has been brought up and documented to the building commissioner, Brian Florence, in a letter most recently of January 22nd, 2025, but has also been a part of numerous other pieces of correspondence. I did send the board a letter dated February 25th of 2025 that does append the documentation in that letter to Brian Florence. And the structures I would submit to the board are consistent with the rest of the neighborhood in terms of size and setbacks on the lot. As shown on the site plans prepared by Sullivan Engineering and Patrick Ahern Architects dated December 19th, 2024, we are seeking to transfer that use. I would submit to the board, just running through the special permit criteria, that the application does fall within a category that is accepted under the ordinance for the grant of a special permit, that section 9424 of the ordinance, or 240-94B of the ordinance, along with section 125 and general laws 48 section 6, does allow the board to grant a special permit. I would submit that the proposal is not substantially more detrimental to the neighborhood than the existing use, that the applicant, that we had the use in the apartment unit that was, well, we have had 3 units, dwelling units. We're staying with 3 units. We're not increasing the number of dwelling units.
I took myself off camera and video. I mean, yeah, I'm thinking you should.
Additionally, the nature of the use, it will remain as an apartment unit, or in, I don't know if someone else was talking, remains incidental and subordinate to the principal use. And finally, after reviewing the letter dated January 22nd, 2025 to the building commissioner and a telephone call that I had with him, that there was no objection at all from Brian Florence, and he was the one that requested the relief from this board. According to the site plan by Sullivan Engineering, we are maintaining the setbacks. We're not increasing anything into a setback in the RF1 district. And the proposed use is going to remain on the same lot as it was when it was created, which was lot 170 on Land Court Plan 572562 and Land Court Plan 5723B. And that has not changed since that use began. And based on the following, would respectfully request that the board issue the special permit, and happy to answer any questions that you have. I do have with me this evening, I do see John O'Day, the engineer, and I do see Alicia Fix. Thank you.
Attorney Schultz, is the site plan you're referring to, maybe I missed it, but I don't see it in our files. And was that in there? Did I miss that?
It was submitted with the application, but it's also, do you have the letter?
I have the memo, yeah.
All right, so that would be
Which exhibit?
Exhibit 5, I believe. Exhibit 5. And on that, Chair Dewey, I do have what's labeled as the garage, highlighted in yellow. That is what is the golf cart barn. It's just been, the terminology's been changed.
The site plan is within the application.
Okay. Any board members have questions for the applicant?
Just really quick, just for more clarification, I'm sorry, I got a little distracted in the beginning. So the and my stuff's loading really slow here. So the golf cart barn is to be built. This is a proposed barn, correct?
That is correct.
Proposed dwelling. And so all you're doing is just removing from the principal residence, you're putting into a proposed sub 900 square foot golf barn.
That's correct.
Okay. And then obviously you lose a bedroom or a whatever from the principal residence.
Correct. And I'll let John O'Day, the engineer, handle the septic flows, but that is correct. Yep.
Okay, thank you. That was just for clarification. Thank you.
Yep. you're
Yeah,
welcome.
unfortunately, when the site plan is in a memo like that, I can't zoom in far enough to read anything.
Me either.
It was submitted with the application separately and along with the elevations that Ahern. So the memo was just in addition to what was submitted previously.
Am I
John,
missing that, Anna, somewhere in the file?
Is it in with the exhibits?
Well, it's in the exhibits in the memo, but they're so low res that you can't zoom in.
I'd be happy to bring it up if I'm allowed to share, if you'd like to see it.
I think David can give John sharing.
Yeah, he's all set.
Okay, 1 second. Make sure I'm clicked on it. Okay. And I want this. That should be popping up for you right now.
Oh, there we go.
So this is the primary dwelling that's under construction. This is the guest house that's under construction. This is the pool cabana or accessory structure. And this is the garage, AKA golf cart barn. So it does meet the front yard setbacks, side yard setbacks, all structures meet setbacks. And the number of bedrooms overall on the property has not changed from what previously existed. They've been passed around between the different buildings, but we were 7 and we are remaining 7. We have septic permits for 7.
Okay. Mark or other board members, any questions for the applicant?
Yeah, this is Paul. I have a question. What is the specific issue as to why you're here?
Well, when we purchased the property, Paul, the principal dwelling had an apartment unit that was attached to it. And what we're doing is, so that principal dwelling contained really 2 dwelling units. And now the principal dwelling is only 1 dwelling unit. We're transferring that unit from the former principal dwelling to the golf cart barn.
The issue is you want to build a 3rd building on the property that houses, an apartment.
Correct, or the 3rd dwelling unit that we had at the property when we purchased it. It's just a requirement that the building commissioner, when you are altering a legal pre-existing non-conforming use, if you're altering that in any way so that the principal dwelling, you have to have a special permit to authorize that transfer to a new separate structure.
Thank you.
Anyone else have any questions? Aaron, Herb? All right, I'll open for public comment. I don't see anything that we've received. Is anyone here to speak to this item? David, anyone that you know that was trying to get in regarding?
Not that I know of.
Okay.
Just Sarah did the vetting of the public, but yeah.
And Anna, nothing that you received?
That's correct.
Okay. So I'll make a motion to close public comment on the item.
Second.
Roll call vote on closing public comment. Herb Bodenseek.
In favor.
Paul Pinard.
In favor?
Mark Hanson.
I'm in favor.
Aaron Webb.
Favor.
And I'm also in favor. So public comments closed. Before we close the public hearing, does anyone have any other questions? No?
Pretty straightforward.
Yep. All right. So seeing none, I'll make a motion to close the public hearing on appeal number 2025-001. Give me a second.
Paul,
Second.
All right. Roll call vote on closing the public hearing. Herb Bodenseek.
In favor.
Paul Pinard.
in favor?
Mark Hanson.
In favor.
Aaron Webb.
In favor.
And I'm also in favor. So it brings it back to the board for deliberation or to make findings. Does anyone have any thoughts or want to propose findings?
I just have a real quick question. I mean, we're sort of looking at what would be considered an ADU in essence, but it's being termed as a golf barn. And I'm not proposing that to the attorney necessarily, just back to the board real quick. I mean,
It's already existing though, within the main unit. They already had 3. So they still have 3. They're just moving it. It's not a creation of a new unit. Technically.
well, yeah, not technically, but it's a creation of it. Yeah, you're right. I mean, but it's a new structure, right? So it's, anyway, yeah, I'm good. I mean, seems like it fits within the parameters of the property, and so.
I'm happy to
Someone
make.
make findings? Go for it, Mark.
Let me just ask a question because I'm a little hazy here. If I had a principal residence that had 2 apartments and whatever, I could move those 2 apartments out of my principal residence and build 2 separate structures with that's what I don't understand is.
That's correct. And so but you would have to, if it's a legal pre-existing non-conforming use, that's why I'm coming to this board when I'm transferring it out of that principal structure, Paul. So if you had, for your example, those 3 units, you could transfer them into separate structures. You're not intensifying the use in any way, right? So you're not increasing, you're not going to 4 apartments, you're keeping your principal dwelling with your 2 or your 3 apartments. Does that make sense?
Yeah, okay. Thank you.
Yep.
But can I ask a question?
Go for me. I mean, we did close the public hearing, but yeah,
I know,
we can
but
deliberate
it's
amongst
just
ourselves.
for the board, because it would just seem to me that part of the reason that this is a pre-existing non-conforming is that at the time these use was created, there was no zoning. If we're creating a new, it would seem to me that the logical, and I understand not doing anything beyond what currently exists. They're not further encroaching. They're not creating additional usage on the property. But something about it that's troubling, because now that there is zoning and they're building anew, should they not comply with the applicable rules?
No, because there's 3 units. They bought it as 3 units. It was legal 3 units at the time they purchased. There's still 3 units.
It's not a matter of the time they purchased, it's the matter of when zoning was enacted.
Exactly.
Yeah.
And I know what you're saying, Mark, in that they're not doing any more. They're keeping status quo, let's put it that way. And I get that, but it seems to me that the intent of zoning, once it's in place, is that you comply with it. And nothing's forcing them to abandon the current use. Right? I mean, that's pre-existing non-conforming, they can continue it. But to move on and build anew, seems like that ought to comply with zoning, but just a thought.
Paul, Herbert, looks like you're trying to say something, you're muted.
Nope.
Okay. Does anyone have more thoughts? Does someone want to make findings?
I guess my question, again, going back to Manny's point, is where are they not conforming to zoning? I mean, they're all within the setbacks. They're not encroaching upon, asking for a variance for those reasons. So I guess what I don't understand about Manny's point is, where are they not meeting the zoning?
I think it's the use.
It's the use. May I comment, or is this just deliberation with the board, Chair Dewey?
I mean, you can comment to give us a little clarity here.
Right. So we're not increasing anything. This is purely, as Mark Hansen had said, we're maintaining what was the legal pre-existing non-conforming use when we started. Mm-hmm. So that we had 3 units, we're keeping 3 units. So we're in full compliance with zoning. Since we're transferring it out of what used to be in the principal structure, we're seeking this special permit, which is it substantially more detrimental to the neighborhood? And that's the standard under the.
But we are calling it expansion.
Correct, and that's what, for the deficiencies of from our own zoning bylaw, that's the only avenue that it comes under. I did submit in my memorandum and did go through with the board that a 40A Section 6 finding is what's required, which is it substantially more detrimental? That's what the case law requires. It comes under your zoning bylaw. I just did this 2 years ago at 250 Smoke Valley Road, the identical scenario where it was 240-93B.
Attorney Schultz, if this golf barn were not, you were not trying to transfer a unit into it, would that be able to be built by right? Within the coverage ratios and the setback, we know the setbacks match and everything. Is there anything that would prevent that? Would you be here in front of us if you were not trying to transfer a unit into that golf barn?
I would not.
Okay, so.
Point, Mark.
Does someone want to make findings?
I will.
Go ahead.
With regard to special permit number 2025-001, fix 240-94B, non-conforming use expansion. Alicia L. Fix, trustee of the 333 C. Pewitt Road Realty Trust, has applied for a special permit pursuant to section 240-94B, non-conforming use expansion. The applicant proposes to alter pre-existing non-conforming use by transferring 470 square foot apartment unit located in the former principal dwelling to a golf cart barn. Subject property is located at 359 C. Pewitt Road, Ossipeville, Mass. For all special permit findings, board is required to make general findings pursuant to 240-125C. Board should review the evidence presented by the applicant, staff, and members of the public, and after weighing such evidence is encouraged to articulate if and how the evidence contributes to each of the required findings. Application 1, the application falls within a category specifically accepted in the ordinance for grant of a special permit. Find that section 240-94B allows for a special permit. After evaluating all of the evidence presented, proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. I find that the style as presented and the fact that it does meet all general setback requirements and lot coverage ratios as presented. Number 3, a site plan has been reviewed and found approvable with conditions. In this case, site plan review is not required. The proposal use and expansion is on the same lot as occupied by the non-conforming use. On the date it became non-conforming. Proposed new use is not expanded beyond the zoning district in existence. The date it became non-conforming. At the discretion of the zoning board of appeals, improvements may be required in order to reduce the impact on the neighborhood and surrounding properties included, but not limited to the following. A through D as presented in 240-53, landscape requirements. Those are my findings.
All right, do I have a second for Mark's findings to approve?
I'll second.
All right, roll call vote to approve 2025-001 as presented by Mark. Herb Bodensee.
In favor.
Paul Bernard.
Favor.
Mark Hanson.
I'm in favor.
Aaron Webb.
In favor.
And I'm also in favor. And then Mark, conditions on 2025-001.
Yes, with regard to staff report dated February 6th, 2025, I have suggested special permit conditions number 1 through 4. Attorney Schultz, have you reviewed these and are they acceptable to your client?
Have reviewed them and they are acceptable. Thank you.
I guess my only question on those is, are we saying that this is a full build out of the lot?
Build out, I was just going to ask that. Yeah. Can we add a 5? Is that?
Yeah, because 3 is kind of vague. It's like no further changes to the apartment unit use located. Like, I think it should be a full build out lot without coming back to the board.
Without coming back to the board. Would that be okay, Attorney Schultz, if we added that as a number 5?
Well, I think
you've already presented that things are in process maybe beyond the plan of what we're seeing.
Right. So I guess just given the scope and the size of the lot and what's being done, I think coming back to the board, that's why, the intent was to hopefully limit it to this particular golf cart barn, not providing oversight on anything at the lot. Everything has been done within setbacks. We're not encroaching into any setbacks. We're not doing anything that we shouldn't be doing at the lot. This is simply a transfer into a detached structure. So I think it's a little bit distinguishable, in my own opinion, from a typical thing that comes before the board, given what we're doing at this particular property.
I'm not comfortable.
I don't know how
I would want a
break them
5
up.
myself, but
Yeah.
it's a pre-existing non-conforming. It's expansion of a pre-existing non-conforming. So we're giving expansion, and I don't want there to be any more expansion without it coming back to the board for a hearing.
Can we not,
Other board members,
not
I'm just one
reference-
vote.
Can we not
Other board-
reference this?
Can I just conference?
Sure.
Yep.
I'll just be 1 second, Chair Dewey and members of the board. Sorry.
No way.
Excuse me, Jake?
Yep, go ahead, Herb.
Yeah, I'd be comfortable without a paragraph 5, because if you think about it, it's an ongoing project. And if they want to make any change to the building permit that's totally unrelated to the apartment, they have to come before the board if we put that paragraph 5 in.
It would only be unrelated to the use.
Okay.
So they could essentially make the golf cart barn bigger as long as the use didn't change.
Hmm. It does say the word use. Maybe take the word use. I don't know.
I mean, we're not saying they can't do anything. They just have to come back to the board. We're giving them a expansion of a pre-existing non-conforming. So I just don't think it's unreasonable to come back to the board.
Just gets confusing if they wanted to expand a deck that they had plans for already on some. I'm not sure the scope of the whole project outside of this golf cart barn here, but there's other things going on. So if they want to do any changes,
it would seem to me that the reason for moving the use from one location to the other is because they have plans for the location where the use is currently being made. Right? I mean, that sounds logical to me. And if they want to do anything there, I think it's not. Anyway, I'm not on this panel. I apologize.
Chair Dewey, I'm happy to try to limit the scope on, to the barn. And I understand your point about there is absolutely no intent to expand the size of the golf cart barn itself. My hesitancy, and I think from my client's standpoint, is we've got such a large, all-encompassing project. I think it's been in the ground for 2 years, and we're not even, so anything, what I'm trying to save is cost coming back before your board and administratively for anything that touches the property that we have to come back. So if we can structure it so that No further changes to the apartment use located in the golf cart barn or the golf cart barn itself shall come back to the board. Would that cover your concern that we're not increasing the use or the structure itself for the golf cart barn? I just don't want, if we're making changes to the principal dwelling or to the guest house, that we're then coming back to you.
So I guess to Manny's point, what's going where this apartment was? What's that becoming?
It no longer exists, and that's what I tried to describe in the presentation. When we bought it, the principal dwelling contained an apartment unit that was attached to the house. That's a legal pre-existing non-conforming use that the client is able to pull out of that house and put in a detached structure. So there is nothing going in the main house. That is a single family home that has a permit that's been issued. It has one kitchen. It's a lodge. It's a house.
Other board members, Paul, Mark, where are you guys go? Aaron?
I'm agreeable to Attorney Schultz's comments there that we limit it to changes to cart barn size and scope and usage. Because I do agree it's a project that's underway, and I think it does mean that we're going to be, he's going to have to come to us for every single change that's, going forward. So,
Paul, Mark, are you?
Yeah, and I'm not versed enough to, if you remove something, does it, I'm assuming the use carries. I'm assuming they didn't lose the use when they did that. I'm fine with, I would actually be fine with the way it's proposed as on the drawing, but that could change as well. That would still trigger their concern. I mean, I guess it's the barn that's before us, but yeah, go ahead, Aaron.
I'm slightly confused, Mark, about what you just said there in terms of you're not versed on so they lose the right though for the apartment in the principal dwelling?
I don't think so. No, I just don't know enough about it. I don't believe there's any
again,
issue there.
they're not expanding. Well, technically they are expanding, but they're not changing the amount of bedrooms on the lot, correct? 7 is the 7.
Correct.
So if you take one from the principal dwelling, now you're down to 6 inside, again, for instance, adding one to the cart to the golf barn. How do we go backwards to add an apartment per se back? Again, this is sort of semantics. I'm just curious, back to the house again.
Well, they could build anything. They could build a gymnasium on the lot if they really wanted to. They could build a barn. They could build a 10-car barn.
Yeah.
Sure. So again, I think our concern initially was we don't want them to expand the footprint of the golf cart barn, therefore expanding the size of the apartment above. As Attorney Schultz referenced, he would be fine with us, adding a condition that any changes to golf cart and or apartment size needs to come back for further review.
Paul, where are you at with this?
I think I'm with Aaron. I think, I'm, having a difficult time by thinking that they could build, 2 or 3 more buildings on the lot. But this is constrained specifically to this apartment switch or movement. And as long as they cannot change the apartment use or size, I think that's within the scope of what we're ruling on.
And I can't see it, but there are drawings that show the size of the apartment and their schematics there and elevations. I was just having a hard time loading it, so reference the documents of December 19th, 2024, I guess.
So, Mark, do you have sort of a proposed 5th condition, I guess, or modification?
Yeah,
to
so I guess for number
condition?
5, we would be saying that this shall constitute a full build out of the proposed golf cart barn as proposed in drawings dated and submitted to the town dated December 19th, 2024. Any other any other expansion of that use would have to come back to the board.
Okay.
Does that work?
I think that works. Yeah. All right. So
Bill, is that okay?
No, that's
Yeah.
perfect. That's acceptable. I agree.
Okay.
all right. So roll call vote on the findings as proposed by Mark for 2025-001. Herb Bodensee,
Conditions, correct?
conditions, yes.
I'm in favor.
Paul Pinard,
I'm in favor.
Mark Hanson,
I'm in favor.
Aaron Webb,
Favor.
and I'm also in favor. So the conditions as amended are approved. Attorney Schultz, you guys have your special permit.
Thank you so much for your time. Have a nice night.
Thank you.
Thank you.
All right, looks like we have Mr. McNamara here, so we will do our first item of old business, appeal number 2024-050. Tim McNamara, DBA Holistic Health Group, has applied for a special permit pursuant to section 240-30 Medical Marijuana Overlay District. The applicant proposes to operate a medical marijuana treatment center licensed through a host community agreement with the town council, with the purpose of conducting patient dispensary sales. The subject property is located at 120 Airport Road, Hyannis, Mass, shown on Assessor's Map 294 as parcel 014. It's located in the Industrial IND zoning district. This was continued from January 22nd, 2025. Members assigned are myself, Herb Bodensee, Paul Pinard, Mark Hanson, and Aaron Webb, who are all present. Mr. McNamara, whenever you're ready.
Thank you, Mr. Chair, and thank you to the board for revisiting the subject. I apologize. I was in the breakout room when this was called. Just wasn't able to make it in. So on in the initial hearing on January 22nd, we reviewed probably the majority of the project. Several details were requested for clarification. In that time, we've done some due diligence to do our best to answer some of those questions. So I provided materials to Anna, and you should have them in your packets. Not much has changed, but I'm just going to try to go through them in order, unless there's someone else who would request an order of priority. But to the first point that I have listed here, there was a question in the last hearing about with respect to the buffer zone that applies to the medical marijuana treatment center. And the question was, what would happen if another or conflicting use for the ordinance, i.e. religious place of religious worship or a school, were located within the buffer zone subsequent to the approval here and operation opening of the marijuana treatment center. As I believe the answer from town council was that the project would simply be deemed a pre-existing non-conforming use, but it would not affect the operation of the marijuana treatment center if, in fact, a business of that kind subsequently opened. So I hope that answers the board's question. I'm going to move on, but we can ask questions at any time. Another detail that needed to be addressed was with respect to, we were talking about pedestrians. The ordinance does call upon, certain alternate modes of transportation. So in response to that, I did provide a summary, I guess, addressing in some detail the various forms of transportation that might be used to arrive at the area. The ordinance refers to drivers, pedestrians, cyclists, and public transportation users. So drivers, I believe, was addressed comprehensively at the last hearing. We talked about the site plan. I believe, Jake, that you did want some clarification on the calculations. So I did provide that in the summary. We have 37 spaces, which, the requirement itself is based on a factor of, for every 200 square feet, you do need a parking space available. And so the project, as proposed, we estimate to about 4,600 square feet, which would yield that 37 number, or I'm sorry, would require 23 required spaces so that the number 37 far eclipses that requirement. So, you know, the max of the building itself would be 5,000 square feet, somewhere around that is my estimate. So again, I couldn't see us going anywhere near beyond that requirement. To the point of pedestrians and foot traffic, the site as it stands is accessible to the extent that pedestrians are in the area. There is a safe passage to the entrance via the lot itself. Will, you know, we are changing a little bit the direction of where traffic will come to the entrance, but for that purpose, it is suitable. We're adding, and we had intended to do this, but we are adding a bike rack so that the existing roadways can be used for anybody who would use a bicycle or perhaps a motorized bike to the extent it's legal to arrive and park it there at that location. And I have been communicating with Cape Cod RTA. And I do have a bit of an update. They have 2 routes that presently run along that road at this time. And there's also the DART program, which is Dial-A-Ride Transportation. The 2 routes as they exist, the representative there had told me that they'd both be accessible. To that point, person can simply, you know, flag the driver at the time that they wanted to visit. In addition, to that end, to the extent the bus did not believe it was safe to stop on the property, we have outlined how the bus could pull into the property, make a turnaround, or simply loop around the building and drop the person off near the entrance, so that they could, you know, walk up the ramp to, or however they're ambulating, ascend the ramp to the entrance. And near that area, there are 2 parking spots reserved, which we have changed to slate those for any rideshare or public, you know, whether it's DART or private town taxi, any taxi service, Uber or Lyft could park in those spots while an individual or a patient was visiting the dispensary. We have renderings showing that. I'm happy to pull them up if necessary. Another question was our hours of operation as proposed. I proposed 8 a.m. to 9 p.m. At the outset. And the last most challenging you know, item of the request from last hearing was the the request to contact the chief and somehow inspire the chief to respond to a question about the security plan for the location. I didn't expect it to be as much of a challenge, but I have not received any contact back. In a normal instance, we would use, you know, telephone and email, which I have used to try to contact her directly. In a normal instance, you know, we might try to visit an office to see if someone's there. I don't feel that that's appropriate at this time, but I would like to share with the board, to the extent that there is interest. The requirements for the state are much the same. There is so when we go through this application process, the state investigator that's in charge of the case, once an application is filed, must affirmatively reach out to the police department to very much for the same purpose. There's no requirement to speak to the chief in particular, but they do ask that we, you know, they talk to somebody and look for a response from the local law enforcement, in this case, Barnstable Police Department, to see that they have been acquainted with the project. And as I detailed in the last hearing, I have shared these plans with a detective and a lieutenant detective at the Barnstable Police Department. I've showed them our existing site in Middleborough so that they don't see just a plan on paper, but how that looks in practice, i.e. plenary camera coverage for every square foot of the facility, access controls to every limited access area and further. And so that's as much as I've accomplished at this time. again, I'm happy to share, the text of that reg in this meeting or afterwards. But I am wondering whether it's appropriate to inquire that simply be a condition, either that, the applicant acquires state licensure as a condition to the special permit being valid, or, the same, I suppose, reciting the ordinance itself, that the chief of police speaks to the security plan at some point prior to operations in order for the special permit to be valid. I believe that covers all the details, but I would like to hear from the board on anything I may have missed.
Does anyone have any questions for the applicant? I guess I'll just, if you could give us like an update about where things are in terms of with the vote at planning board, a denial at planning, or a recommendation against to the town council to approve this. I guess where does that stand for you guys?
Could you clarify?
So you were in front of the planning board, correct?
No.
I can speak to that.
Yeah, Jim, can you just give an update on that?
Absolutely. So that's a separate and distinct item. Mr. McNamara is before you for medical marijuana at this location. There is a separate proposal at this time before the town council, which then forwarded to the planning board, a petition article, a citizen's petition article for recreational marijuana, not site specific, though they did outline a district which would include this location within the district, because they include all of the medical marijuana overlay district. And that citizen's petition, yes, that was not recommended by the planning board, but that is just a recommendation, and then it goes to the town council, which it's currently working towards that recommendation being moved to town council. There's no agenda item at this time for the town council.
Okay. So if that was approved at the council level, it would open up this facility to be eligible to not need a host community agreement and to be a recreational facility, or no?
Not necessarily the host community agreement aspect. It could potentially, the site is within the petitioned overlay or the petitioned district for recreational marijuana. But they would have to go through the process for that. And Mr. McNamara has not stated that yet, to my knowledge, at least, that he was seeking that.
No, if I can speak, I have, the application was very specific that we are looking to service registered patients with the medical marijuana program in the state of Massachusetts. These are people who need to have a qualifying condition to go to either a nurse practitioner or a doctor qualified for that purpose. This is under a separate set of regulations. There are instances where these dispensaries will be co-located. So in that instance, as Jim is sort of describing, it really depends on what ultimately the ordinance in Barnstable would look like, which ostensibly would be crafted by the planning board. But I would envision that the planning board, on advice of council, would have a separate special permit process for that use. So either the planning board or the ZBA would again need to address whether the site is appropriate for that. And then, of course, you have to go through the state process, the entire state process again. But this is for the purpose of servicing anyone over the age of 21 or older. And there is no requirement for that person to be a patient. There's a lot of differences between the medical program, which has been in existence since 2012, and the adult use program, which came into existence in 2016. So I hope that clarifies things. There would be no, if there's a concern, there would be no, grandfathering or anything like that going on. I'm sure that the town would make sure of that in addition.
Okay. Thanks, Jim, for that clarity. And then, Jim, we really haven't done any of these before. The security plan thing in the chief of police. I mean, in the ordinance, it's written as a requirement, a special permit requirement. I mean, how do you recommend we deal with that? It doesn't seem like it's something we can really condition.
Yeah, unfortunately, I'm happy to work with Mr. McNamara to work with the chief in reviewing that security plan. You're right, the ordinance does specify very specifically the chief of police. You could, I would be hesitant to condition it just based on the requirement as outlined in the ordinance, and so. That's unfortunate that hasn't occurred to date, but I'm happy to assist in fulfilling that process.
As an applicant to the ZBA, I mean, I don't have any authority over the police department to speak to this matter. So is there any other avenue we could entertain here? Because again, I want to work positively with the police department, and we have been working positively with the police department. I believe that this puts that relationship at risk, I guess, from the outset.
It's just hard because the way that the bylaw was written, it's tying our hands to it. Like, it's not really a discretionary thing. If it said a satisfactory security plan, we could have that discretion, but it literally is a requirement for us to approve. It's a special permit requirement. Did Lieutenant Kelsey, can't sort of connect that somehow?
He's been radio silent ever since he took a tour. I mean, he was thankful for at that time. Again, I have friends on the force. I've reached out to them. They said, I guess that she can be difficult to reach. And I guess to what his recommendation was, copy, the town on the email, and maybe, that might help. I'm not quite sure how to approach this. I can re-engage, I suppose, with Jim's help, perhaps, and see if maybe he can get somewhere.
Okay. Yeah, I mean, that's just one of my concerns. And then I think you submitted them before. I don't see them, but the elevations of the sign, elevations.
We submitted those.
I saw them. I just couldn't see them today.
Yeah, we submitted those as part of the submission for this continued hearing. I can try to pull them up. I do have Adam Higgins on the call as well, who is project manager and has been helping us with the drawings. If you wanted a 3D rendering where we could navigate, in sort of 3D space around it, do that, or we could start with the stills that I submitted.
I mean, I'm just trying to check the boxes here on these special permit requirements. We haven't tackled one of these before, and these are just requirements. They're not really discretionary items for us. Like it says architectural drawings of all exterior building facades and all proposed signage specifying materials and colors to be used. So I was making sure we had that.
Of course, yeah. So would you like me to share
sure.
something? Okay.
Yeah, sure. I guess I don't see it here.
Let me share what I have for full scale stills. 1 second. Okay, everybody sees this picture?
Yep.
Okay. So here's one area where you can see the sign and its location. That's the existing location, the former Barbie Ann sign. From a different angle, we have one down here. I can zoom a little bit. Again, that's just a template for the sign. If we'd like a little more clarity, again, I can pull up ask Adam to share his screen, perhaps, if there's interest from the board.
You guys aren't chopping the roof off the building, right?
No, we
okay.
just hadn't gotten that far in the design phase here.
Because again, it says elevations are supposed to be part of the.
Yeah, and we submitted elevations, that showed.
I don't see them in the folder right now, man.
Oh, you don't see those? Okay, all right. We submitted different elevations, so we had engineering elevations, and then we're going through the construction and just sort of looking at the building itself.
Okay, there. Never mind, I found them.
Okay, you have those.
Okay, so yeah, I guess the thing that I think we kind of said that was missing last time was an elevation of the signage, and I think you submitted some sort of drawing of a sign, right? Didn't you?
Yeah.
Right too.
Let me see here. Maybe I think again. Okay. So you want?
Yeah,
something...
I definitely could go over the sign. Very precisely, measurements, everything. Sorry, yeah, it's not the primary object in some of those views.
Yeah. Again, I'm not trying to be a pain. I'm just trying to check these boxes and these requirements to make sure we have the full thing together.
Is there just the two signs? The one on the building and the one on by the entrance?
Yeah, that's correct. The only independent sign is the one that was shown on that plan. Adam, do you have a better drawing of or elevation showing the sign?
Yes, and I do apologize for not having the 3D chops to build that roof quickly. But yeah, just thought the first story would give the context. But yes, this is the existing sign. So the 5 feet tall and then 6'3" to the peak.
Okay.
Chair, if we submitted a still of this, would that?
Yeah, I think that's fine. Again, it's just checking the boxes and make sure it's in the file. Is that going to be lighted or not lighted?
I believe there's ground lighting.
Okay. I think all that stuff will just follow regular sign code.
Yeah.
And those are the things I had in my notes, is just trying to, really check off. Any other board members have questions or?
This is Paul. I mean, does the signage conform with the signage requirements of the town?
I believe it will have to. I mean, our requirement here is that we have architectural drawings of the exterior building facades and all proposed signage. I think that would fall when they go for a building permit. It will come up there.
They'll have to have dimension sign drawings.
I mean, the issue would be is if then they say it has to be a different sign, and they have to come back to us again to, update this special permit package.
Mr. Chairman, real quick, it doesn't appear to me like we're going to get there tonight, given the fact that we don't have a security plan yet. Again, no offense to Mr. McNamara, it sounds like. So should we move to continue?
Yeah, I mean, I think we should just make sure, is there any other, do we feel, for his benefit, can we narrow it down that's all basically he has to come back with to move this forward?
And can he access the requirements for the zoning that you are looking at?
Yeah, I mean, it's in our code. I mean, that's our.
Okay, so I think he's willing to do that, and I think we should move to continue.
And I think
unfortunately, Mr. McNamara, we're not going to get anywhere at this point. It appears like, again, no offense to your efforts. It's just, we can't check the box, and it seems like a pretty big one. Unfortunately, this is, I'm not even quite sure what the word is, but I'd rather just, make sure you have access to what is required of you. And I think the biggest piece we're stuck on here, and I wish I could offer your solution. Unfortunately, I think you're working towards it, right? Jim, you can try to help him. And
okay, is there a way that you could reach out to the chief and say, hey, we need this box checked and that's all we need?
I think Jim will have good contact.
Yes, I'll certainly reach out to her tomorrow.
It is a town requirement. I mean, we have to be able to reach out to these people and have some sort of communication. I mean, that's only reasonable.
Yeah, I mean, otherwise this bylaw needs to be amended if it's not something that the chief's willing to do. If she's not willing to sign on that, then it needs to be changed. That the state state requirements just have to be met or something.
Right, correct.
Just
been through
because people may have been here and sat through the time, I just want to make sure public comment's still open on this. I don't think we received any new letters than were read in last time, or were two of these new, Anna? Let's see, what's the date on this?
We did get new ones.
Yeah, there was one from Rick Yard.
Marty
Yeah.
And Craig, Jean Mary.
Craig, yep. Letters of support.
Yeah, okay, so we did receive 2 letters of support. Is there anyone here that wanted to speak to this? Yep, go ahead, just unmute yourself and say your name and address for the record.
Hi, yes, my name is Peter Cahill, and I'm a resident of Centerville, 83 Naughty Pine Lane, as well as a local business owner. And I am also in support of this medical cannabis facility, treatment facility, as I am also a registered caregiver for my adult stepdaughter, who suffers from medical conditions in which cannabis explicitly helps with her treatment. And up till, hearing about this, providing, and obtaining her prescriptions, would require traveling at minimum 2 towns over. So, I would just say moving forward with this, myself and dozens, if not hundreds of others would be greatly appreciated of the convenience of having this kind of facility within our town. And on top of that, it's, as the largest town on Cape Cod, it kind of stands to reason that, those kinds of things would inevitably be available here. And I do view it as a need. So just wanted to thank you for your time on this and just to provide my opinion. Thanks.
Thank you. Appreciate you being here and staying for so long. Is there anyone else that wants to speak to this? We will leave public comment open. I think, just till we get this fully wrapped up.
Jake, can I say something?
Yes, of course.
Yeah, no, I find this disturbing about the inability of the applicant to get what he needs, to fulfill this. And thank you, Jim, for stepping forward. And if you could please let me know tomorrow what you find out, because again, it's the town council that passes this stuff. And if we're passing something that is just this difficult to do, I'm completely in support of this. As much as I am completely not in support of the recreational. So I like what the planning board did with that. I don't want the two to be confused with one another. They're very different and distinct. And I'd like to make sure, we help the applicant. He's been working on this for a long time. And I think we owe that to him to help him because he's been so diligent. Thank you.
Thank you, Councilor Lepke. What, Jim or Mr. McNamara, what do we think about timing to continue this too? I mean, it seems like all of the hard work has been done. I don't know if the chief's going to come back and want other things that would take time to get, but it seems like everything's together to put in front of her. It's a matter of whether she's willing to sign her name on it. I don't know.
Yeah, I mean, I've provided her in writing, as much as I can in terms of the security plan detail.
So, Chairman, I'm happy. So I'll certainly reach out to her tomorrow, certainly maybe continuing to the very next meeting, and I can give you an update before that meeting as to whether or not we've accomplished what's needed.
Okay. Mr. Mac, our next meeting is March 12th, which is in person. Is that work for you guys? I don't know where you guys are, regionally, or would you rather wait until March 26th to be remote?
Local, I'll be there.
Okay. All right, so I'll make a motion to continue appeal number 2024-050 to March 12th, 2025 at 7:01. Yep.
Jake, well, before you do that, I will not be there, and I don't know about Manny. Manny, are you going to be back?
I don't know if Manny's still here.
Yeah, he's just trying to
unmute.
Oh, there you go. I'm muted. Yeah, I may have a problem with the 12th.
I will not be present either.
Sorry, gentlemen. And ladies and gentlemen.
Maybe a difficult date.
Tim, let's just go for the 26th. It sounds
I
like.
guess we go for the 26th, or we can leave it on the 12th, and if our members aren't there, we'll continue it then to the 26th. You guys wouldn't have to be there because it's a quorum issue on our side, but it's up to you guys. If you want us to plan for the 26th, that's fine too. I hate to keep pushing this out on you guys.
Well, I think according to the guidelines, if it's continued on that date, they have to be there. Somebody has to be there to continue it in person.
I thought not if it was a quorum issue on our part. Because we would need...
Correct. You're correct.
We would need 3, right, to approve it, Anna? So if we don't have... It would just be Mark and I that would be left. We would need one more person.
No, but everybody's been here. Can they not read in?
We could mull someone in, Anna, yes?
One person can mull it in.
And then if we were in full unanimous agreement, it could pass.
If it was Larry and Herb and you and I, we might be able to, right?
Who's on this? Yeah, it would be you, Herb, and I.
You need 4, so that'd be Larry. Yeah.
Does that work, Anna? Are we?
Jim, do they need 4 to continue or just 3?
To approve.
Need 3 to continue the matter,
Right.
4 to approve.
4 to approve.
Was Larry here for the other one?
Yes, I was. And let's let the applicant as well pipe in, because just so he knows that as he presents, there will be less bodies potentially to offer a swing vote.
Dave, you think we should go to the 26th? Or?
Yeah, it's close.
I'm inclined to do the 12th. I mean, they can continue.
All right. I'm ready to go.
I mean, you guys can always continue at that time. If for some reason the 4 of us, someone's dissenting and it, whatever, you always can say, let's continue.
Okay.
But if Larry, you're willing to mull it in, I want to try to get this done for you guys.
I appreciate that, Mr. Chair.
I heard both here. Is there some way we can get an idea of how the 4 of us are leaning? I would be leaning in towards approval.
I mean, with what's presented so far, I'm leaning towards approval. I just don't know what would, anything could happen at the next meeting, or the chief could say, she's not comfortable with this, and then I guess we can't actually approve it. It's something that if we wanted to, I don't think we can.
Based on current submission, I would be moving towards approval.
And so you have the 3 of us. Larry, you would be the 4th. I don't know how you're feeling.
No, I'm leaning towards approval, but like you said, we need something from the chief.
Yeah.
That's the issue.
So if we continue to the 12th, unless one of us is, not able to attend, then that might be the way to go for the applicants.
Yeah, I mean, it's up to you as the applicants, but I'd recommend going to the 12th. If something comes up, and we usually let Anna know if something comes up at least, a day or 2 before. And so that she can say, hey, you need to continue. And
we can continue with 3 anyway, right?
Yeah.
Yeah, so.
Aaron, go ahead.
Yeah, just lastly, just so the applicant knows as well, that if you need to continue because you haven't heard from the chief yet, that there's a timeline in which you need to do that, so you don't have to appear in person. So, but you can find that. Anna can help you with that, I'm sure.
Good point.
All right.
So the 12th or the 26th? Your choice.
12th.
All right. 12th. So I'll make a motion to continue appeal number 2024-050 to March 12th, 2025 at 7:01.
Second.
All right, roll call vote on the continuance. Herb Bodenseek.
In favor.
Paul Pinard.
In favor.
Mark Hansen.
I'm in favor.
Aaron Webb.
Favor.
And I'm also in favor. And then Larry, you'll work with Anna for the Mullen and on that.
Okay.
All right. Thank you guys. Sorry we couldn't get further tonight, but I think we're real close. And thank you, Councilor Ludke, for offering to help, make sure that they get what they need.
Thank you, Councilor, and the board. I appreciate everyone's assistance.
All right, our final item of the night, appeal number 2023-010. Arista Hyannis LLC has applied for a special permit in accordance with section 240-25B22 and section 240-25C10 drive-through for a proposed restaurant. The applicant proposes to remodel the former bank building and change the use to a food service establishment with a drive-through. The subject property is located at 715 West Main Street, Hyannis, Mass, as shown on Assessor's Map 249 as parcel 155. It's located in the Highway Business HB District. The Land Court, in an order issued on January 28, 2025, following an appeal of the board's previous denial of the special permit, has ordered the matter remanded to the Zoning Board of Appeals for further deliberation in accordance with the terms of the order. The board will consider the matter in accordance with the terms of the court's order after judgment with no further public comment. The members sitting on this, Anna, correct me if I'm wrong, are Herb Odenseek, Paul Pinard, Mark Hansen, myself, and Denise Johnson, who's no longer a member of the board. Is that correct?
I believe so. Attorney Conley is here to make sure.
I thought I was on this one.
Oh, maybe it was, I think you might be right.
Manny was
I just
on
don't
it.
have it written on this.
If I may, Mr. Chairman, yes, Manny
Yeah.
was one of the members. I understand the only difference is that one of the members, Denise, I'm forgetting her last name. Johnson is no longer on the board. The person that replaced her is not here tonight, but she wasn't part of this hearing. And this is a continuation of the deliberations. The judge basically sent it back to continue the deliberations, essentially. So we need to have the same people that were on before, minus the one, obviously, that isn't on the board anymore. So Manny was one of the people that voted.
Okay. So it's Manny, Mark, myself, and Paul, or Herb?
Anna, could you check the minutes? Or the decision? The decision should say it.
The decision says... Herb, Denise, Mark, Manny, and myself.
I've got Jake Dewey, Herbert Bodenseek, Denise Johnson, Mark Hansen, and Manny Alves.
Okay.
So I was not on there.
Does not appear you were a voting member on this based on the decision. So deliberating this will be myself, Herb, Mark, and Manny.
Paul was a
Correct.
regular member. Why would he not have been a voting member on that? Maybe he wasn't. Well, you were present, right, Paul?
He was present. I watched the hearings and he was there and part of the discussion, but I know the way that you all do it is you appoint who are going to be the voting members. Let's just
Maybe
make
he
sure
wasn't.
we have-
Maybe he wasn't there at the first meeting.
I don't know.
I was there at the first. I wasn't there at the second, I don't believe.
Let's just make sure that we have a quorum of people who can vote on this tonight.
Okay, so I believe we have the four that voted on the original decision, based on the signed decision, is myself, Herb Bodenseek, Denise Johnson, Mark Hansen, Manny Alves. So we have everyone except for Denise here that was sitting on this, correct?
Correct.
Okay, well, four would be a quorum. And if it's unanimous, that's the satisfactory quantum of vote.
Okay. So where's is the judgment in here? It's not in my folder. I mean,
I did email it to the board members.
yes. All right, so the judge, we're reading what the judge's decision was. So the judgment stated plaintiff Arista Hyannis LLC filed this action in February of 2024 pursuant to General Law, Chapter 40A, Section 17, Mariska sought review of a decision by the defendant members of the Zoning Board of Appeals of the Town of Barnstable, the ZBA, filed with the Town Clerk of Barnstable on January 26, 2024. In that decision, the ZBA denied Arista's application for a conditional use special permit for a drive-through at 715 West Main Street in Hyannis, Massachusetts. The parties appeared for trial on January 27th, 28th, 2025. For the reasons stated on the record at the conclusion of the closing arguments day, reasons that constitute the court's findings of fact and conclusions of law pursuant to Rule 52 Mass R Civ P, the findings and conclusions, the court orders, adjudges, and decrees that judgment hereby enters in favor of Arista and against the Zoning Board of Appeals on Arista's amended complaint in this action. Orders, adjudges, and decrees that the Zoning Board of Appeals decision and notice in special permit case number 2023-010 filed in the Town Clerk of Barnstable on January 26, 2024 is hereby vacated, and the case is remanded to the ZBA for further proceedings in accordance with the court's findings and conclusions. Such proceedings to commence within 45 days after entry of this judgment. Order, judges, and decrees that without limiting the foregoing numbered orders, the board on remand may not consider the impacts of Ariska's proposed drive-through on A, traffic generation, B, the circulation of traffic within the property 715 West Main Street, including but not limited to the amount of queuing within the site, C, parking within the site, and or D, pedestrian or vehicular traffic on or along West Main Street, Pine Street, or the intersection of those streets, and orders, adjudges, and decrees that this court shall retain jurisdiction over this matter to the extent of any of the parties to the proceeding wishes to seek a further relief consistent with this judgment, or B, review of the ZBA's actions on remand. And this was ordered by Judge Michael D. Bay. So in that case, we have to reopen this for deliberation and a vote based on the judge's order. Does anyone have any questions for Attorney Conley? Attorney Conley, do you have any direction for us or questions for us?
Well, as we previously discussed, the judge has not given you a lot of discretion here. The board decided not to appeal and to comply with the court's order. One of the issues is that the zoning was changed a few years ago to allow by special permit in this district drive-throughs to restaurants which are allowed as of right. So the board, the court has ordered the board to reconsider this, but not to consider any of the issues with respect to the drive-through. And keep in mind, it's only the drive-through. It's not any of the other issues that people were complaining about at the hearing that relate to the restaurant. It's with respect to the drive-through. So not being able to consider all of those things means unless there's something else that the board can come up with respect to a finding that relates only to the drive-through and that it shows a substantial detriment to the public good, then the court has ordered that the board issue the special permit. We did discuss whether there'd be any additional conditions that could be attached. And I know Anna provided a staff report that you each should have gotten. So that's something that you should consider in your deliberations. And I'm happy to answer any questions, but
I have a question, Attorney Conley. You said that the judge ordered us to issue this?
that's correct. That's what a remand is, as we discussed at the executive session.
No. A remand is for us to reconsider the matter. It told us what we can't, it admonished us as to what we can't consider.
That's correct.
The items, but it didn't say reissue the special permit or issue the special.
But unless you can come up with a reason to deny it, if you look at paragraph 3 of the 4 paragraphs that Chairman Dewey just read, paragraph 3 does not allow you to consider all of the things with respect to traffic and queuing that the board was concerned about with respect to the drive-through previously.
Oh, I hear you, and I feel strongly about this. Mr. Chairman, if I may be heard on this?
Yes, please, go ahead. We are deliberating.
My view on this is the judge did not say anywhere that the ordinance of the town of Barnstable is in any way invalid or unlawful. The ordinance, in question, this is 24025C, says that in addition to the standard special permit guidelines we need to follow. This board has to vote and make a finding that, and I'm reading verbatim now, the use will not substantially adversely affect the, and it lists a number of things, including health, safety, comfort, and convenience of the community. Comfort and convenience of the community. I guess I went back and read the order and looked at my notes from that meeting and my recollection as well. Folks will remember that 91 people either showed up or wrote to the board in opposition to this application. And it was made patently clear that we were only talking about the drive-through, not the restaurant. The restaurant can be built as of right. And frankly, I'm willing to hear to others and be persuaded. But my view on this is I couldn't in good conscience vote to make a finding that this would not substantially adversely affect the comfort or convenience of the community. The community spoke. Now, it is true that a number of them mentioned traffic as their concern. Not all. And I know we've been admonished. We can't consider traffic impact in this deliberation. But I think a number of people spoke about being uncomfortable with having this drive-through across from a high school, from the high school. And I, frankly, that's what persuaded me. That if we're talking about the level of the community, and again, back on C-240, 120, what is it, 25, that this does not, it's a separate finding above and beyond the 125C standards about whether this substantially adversely affects the public comfort or convenience. And I read that to basically make this a higher requirement for the applicant to proceed, because I heard people uncomfortable with having this across from a public high school. And again, I know people, it was said that it wasn't the restaurant. I think it was quite clear at the hearing, at the very least, that the only thing before the board was an approval for the drive-through. Now, I'm willing to hear from others, and I can be persuaded, but I honestly, based on what I heard from the community and these standards in the ordinance, which I don't think the judge said the ordinance, as I said, is unlawful or improper. If we're following the ordinance, I couldn't, in good conscience, vote to make that finding that this is not substantially adversely affecting the comfort of the community. My view.
Manny, can you elaborate? Well, sorry, Kate, go ahead.
I just wanted to, if you're done, Manny, I didn't mean to.
I am, sorry.
Just wanted to respond to a couple of points that you mentioned, because you said a couple of times that the judge did not invalidate the ordinance, and that's correct, he did not. The plaintiff did not request that, and if you do request that, you've got to contact the Attorney General with respect to towns. You don't necessarily do that with respect to a city, but that's true. It was not invalidated, but that really doesn't address the crux of the court's decision, which is the court found, I may agree with everything that you just said, and I tried the case. The court did not agree with us. The court found, even with the concerns that the board had about traffic, that was not a substantial detriment. So that's why previously when I discussed this with you in executive session, without giving away what we discussed in executive session, I suggested that the only way that you could condition this project further is if you could come up with something related specifically to the drive-through that showed a substantial detriment to the public good and the other things that are in the ordinance. And because the judge found that the serious things like traffic were not a substantial detriment, I don't think that the judge would agree with the board. And again, unless someone can surprise me and come up with a condition that it relates to the window, the drive-through window.
I do have one
question. The judge did not agree with us that there was a substantial detriment to the public good, even though that's what the board found, and that's what the ordinance, those are definitions in the ordinance of some of the concerns that can allow the board to deny a special permit. The judge in this case did not agree with us.
If I may, again, I'm not looking at traffic, and that is what the judge wrote. He told us we cannot, he admonished the board not to consider the impact of traffic on this application. I'm willing to
Can you identify those things, Manny? Like what you feel like those items of comfort, convenience only related to the drive-through being there, not the restaurant? Because we know the restaurant can be there by right.
Yep. It's not the volume of traffic, it's who will be driving. It's the fact that the population we're talking about are kids at a high school. That's what I heard at the hearing, folks. Of the people who talked about this, who didn't mention, traffic volume and increases, and were focusing on the high school. The point was, again, not even foot traffic, not pedestrian traffic, but it is the population we're talking about here that is going to be accessing this drive-through, kids from the high school. And frankly, I read this resolution. Initially, I thought, okay, if we're under there's a reason this added provision is in the ordinance, not just the standard 125C special permit, more detrimental to the neighborhood, but in this particular ordinance, it goes further to add those things about comfort, convenience. And again, if there were no fast food restaurants in the town with a drive-through, you can make the argument, yeah, this would add to convenience. Well, obviously, we have many. In fact, a few miles up the road, we have an exact restaurant, a Wendy's, that provides the exact beverages and food items with the drive-through. And I think all of those things, and again, I'm willing to be persuaded, so I'm going to shut up and listen to others, but that is what I walked out of that meeting with, that this, given the standards of the ordinance as written, did not quite meet the threshold.
I still think, Manny, you're leaning back on traffic. I mean, traffic generation, circulation of traffic. So you're saying inexperienced drivers is outside of that?
It's not adding generation. It's not foot traffic. It's not. Yeah, I do think the population, I mean, the thing about this that really troubled me is its location and the fact that there's a high school right across the street. And those people I heard who made that point persuaded me that this is, and again, it's not the volume of traffic. It's where we're putting this next to the school. Anyway, I've said my piece. I mean, if others feel differently, I'm willing to be.
Go ahead, Mark.
Just a thought, so the drive-through window itself incentivizes kids to drive through that intersection, for cars to move through that intersection, not as a traffic flow issue so much, but as a safety concern. I believe, and I can't say because they're probably still going through the study, and maybe Jim can speak to this. Is that intersection one of the intersections that is currently that's being reviewed right now for high traffic incidents?
No, 16.
Or safety incidents?
Yeah, so Mr. Chairman, I could speak to that. So that isn't one that we're reviewing in the road safety audit, I think you're referring to, Mark, list, but that is a limited grant that we received. But we have been analyzing this intersection for safety concerns for quite some time. And as it was mentioned at the hearing, this intersection is listed on our capital improvement plan as a priority of the town, though not, we have many challenging intersections. And so it's not the top priority at this time. And while we were looking at this intersection, this significantly predates this application. So it doesn't consider what this use will do to the impact of that intersection. So we likely will have to revisit the concept for that design there.
I'm just concerned that the window, instead of people walking across, this is going to be something that is going to incentivize people to get into their cars en masse, travel across, and access the they're going to do it going to, coming from. It's not that maybe perhaps it's not that the traffic itself is the issue, but the incentivization to get somebody into a car to make that many more trips, that many more safety concerns, and it puts the public at risk. We've already had 2 weeks ago, someone was hit. A young girl was hit going to access a Dunkin' Donuts. Now, she didn't get hurt on her own. She got hit by a car. Somebody wasn't paying attention. That's not a traffic issue per se, as far as flow or movement through that particular lot, but it certainly does speak to, you know, does it incentivize people to come by car rather than foot?
But remember, the judge is saying pedestrian or vehicular traffic along West Main Street, Pine Street, or the intersection of those streets, we cannot consider. Agreed.
That's correct.
But
as much as I agree with you that it's a concern, the judge limited what you're allowed to consider and basically said you can't consider any of the things that are of concern to the board. Traffic, queuing, and traffic includes pedestrian traffic.
Yeah, it's written as pedestrian traffic along.
And does that include safety concern? Or is that just traffic?
Traffic includes traffic safety.
And at the intersection.
I understand.
Like, the judge really has us stuck here.
Yes, it's a very limited remand.
Question of order, Mr. Chairman.
Go ahead, Paul.
I'm not part of this, but the question I have is, if the board votes against this, is the question to Kate, what happens?
The court has retained jurisdiction to make sure that the board votes in accordance with the court's order. I can't tell you specifically what the penalty could be if the board does not comply with the order, as much as I disagree with it. We did not appeal and we did not seek reconsideration for the reasons we discussed at the executive session. So this is a very limited remand. The board is, and that's why we talked about stating over objection that you're following the court's order if that's what the board decides to do. And so again, I can't tell you specifically what the court will do, but the court retained jurisdiction so that the attorneys can report back as to what the board did, and the court will consider what to do from there.
Could you, are you allowed to remind us what are the potential, I
don't think that would be a good idea to
okay, thank you.
Speculate about things like that.
Okay.
But I guess I'll ask the question. If people disagree, we can just vote.
Well,
is there a distinction to be made? Sorry, Jay.
I think we're all trying to get unstuck on this. We're like, I mean, one of if we go back to your point of comfort and convenience to the community, the fact that the drive-through abuts a residential neighborhood and it's not on the road side of the property, I think is a comfort and convenience of the community issue. If the drive-through was on the other side of the building where it's just abutting the highway district, it would be different. But it is abutting I think it's a multifamily residential place, so it impacts multiple people, multiple members of the community of having this said drive-through touching a residential neighborhood. The ordinance doesn't speak to any requirements that it not be abutting, but I think that does speak to comfort and convenience of the community.
And, I agree with that. And I think also the comfort and convenience of having kids because of proximity to this particular place make people uncomfortable. And I think that is not traffic. It's not volume. It's not increased queue. It's the who will be doing the driving kind of thing. I think that is also distinct from and not inconsistent with the judge's order, I would suggest.
I mean, yeah, I think there's a lot of aspects of the drive-through that will affect the comfort and convenience of the particular residential neighborhood that would be abutting the drive-through.
Okay, point of information. So we cannot use traffic-related issues, which are, I mean, it's a drive-through. It's any issue we would have boils down to traffic, whether it's queuing, pedestrian, West Main Street, Pine Street. But we cannot deny the drive-through on those grounds. But can we? I would assume that we can use traffic and everything else to craft our conditions.
No, the court said you cannot consider traffic.
Well, that's an denial of
And
the.
actually, I might at this point ask Jim if you could, I asked earlier about this. There's a staff report with draft findings and conditions. If everybody doesn't have that, maybe Anna, could you read it to them, or however you typically do it?
It is in the meeting material.
Okay.
Yeah, we have it. I have it.
Yeah, we all have it.
Mr. Chairman, is this considered now? Of course, there was a drive-through, there with a bank. Is this considered an intensified enough use with the location of the drive-through and the sound that comes from the drive-through to be a nuisance to the neighborhood? Certainly, you might be servicing significantly more clientele than a small neighborhood bank. Does that fall under the comfort and convenience? Is it going to be heard? How far is it going to be heard? Has there ever been any testing to see how far it's going to be heard? Those usually are. There's really nothing. There's no obstruction that stops that loudspeaker from speaking all day long, into a neighborhood. It's like a flashing stop sign, like they have up, near the crosswalk that's a block up. It's constant. It's running long hours. That intensified use perhaps is something that might also, and that is directly related to the drive-through itself.
Yeah, the LED sign, the lights, the cars idling,
the sound,
the car headlights coming around the corner, all that stuff. Attorney Conley, go ahead.
Yeah, as we had discussed previously, many of those issues you just mentioned are what the court found were not at issue. The only one that is new, which we touched on a little bit before because staff brought it up, was the issue of the volume of the speakers at the drive-through. That's something that was not a complaint or an issue that the board was concerned about before. It was not part of the discussion at the trial, and it was not something that the court prohibited. So if there was a way that the applicant could lower the decibel levels or somehow make it a little bit quieter, that relates directly to the drive-through, to the place where people order food and where the person inside talks to the person in the car in vehicle queue. But the rest of it are things that the court said you could not consider, and basically said that the critical finding in this case was that the drive-through does not make a difference. The findings that the judge referred to in the order, because it doesn't contain findings, it has these 4 conditions. Those were basically he stated when he issued his decision after oral arguments via Zoom. And we didn't buy the transcript because the judge made his decision. It's not worth spending hundreds of dollars on a transcript to get those last few sentences. So I vigorously took notes. And those were the things that the judge said, that basically he embraced the traffic engineer's testimony, that it's a highway business district that allows for drive-throughs, and that he found it to be a critical finding that the drive-through, according to the traffic expert, I'm not saying I agree with this, but we weren't able to disprove this at trial, but that the critical finding is that the drive-through, the judge believed, would not make a difference, and that queuing would not be a substantial detriment. So all of those things, except for the decibels or the volume level or whatever you want to call it from the drive-through, were things that the court said the board could not consider on remand. So if you want to, maybe if you want to think further about whether you could condition, in addition to the draft conditions that you were provided, some sort of a condition about keeping the volume at a certain level. And I don't scientifically know how that works, but if there's a way to do that, that's something that the court did not prohibit. But all of the rest of it, in my opinion, the court said you couldn't consider.
I believe if when it's regard to rentals and things like that, it's 150 feet.
Oh, you're talking about the distance from?
Yeah, you're not supposed to be able to.
Audible, yeah.
Audibly, I don't believe it's supposed to be heard beyond 150 feet.
Another thing is odor. We had one of our local developers bring up when Chick-fil-A was being proposed.
That's
the
we can't go, Herbert. The restaurant's allowed by right. That's related to the restaurant. The restaurant's allowed by right. It's only drive-through.
Well, I think we need to discuss hours of operations and conditions like that, because the conditions that are proposed definitely could use a little work. The only thing that it says in here is that the drive-through has to be, the hours of operation shall be the same as the hours of operation as the indoor restaurant.
Correct.
And I know in our previous deliberations, nobody, including any of the 90-some abutters and, citizens, nobody wants that place open till 1 o'clock, as Wendy's is so apt to advertise as one of their key draws. And if anybody is out late and goes by the Wendy's at the Rotary, they will see, I know we're not supposed to consider traffic, but they'll see 10 cars there at midnight. And I don't think, if we can't use traffic, there must be some other calculus we can use to limit the hours of operation. And he also said he wasn't going to be doing breakfast. He said his restaurants don't do breakfast, but they do. So
I believe the plaintiffs testified that that was not their peak business. Not that they don't do it, but that it's just not their main thing.
Then he doesn't need to be open then.
Well, you got a Dunkin' Donuts that's just up the street. I mean, I don't know if your hours of this can be different than the hours that's already approved for Dunkin' Donuts.
Well,
we only have authority over the drive-through here. We can't condition the restaurant.
Dunkin' Donuts closes before it even gets dark out half the time. But that's not what we're talking about. We're talking about
the drive-through specifically.
And specifically a drive-through. But if we don't discuss things outside of traffic, I think we're selling ourselves short. Because there were definitely, I've thought about it, and everything boils down to traffic, I have to confess. But there must be something we're missing that the people talked about that were concerns not related to traffic. The well-being of the neighborhood. I think Manny, if we just kind of quantify Manny's concerns somehow, right? Without traffic being entered into the argument.
It's comfort or convenience of the community. I mean, is how the ordinance reads is we have to find that such uses do not substantially adversely affect the public health, safety, welfare, comfort, or convenience of the community.
Well, I think denying the application for the drive-through is simply not going to happen at this point. But we have other restrictions in the way of the conditions that we can put on this, and we have to be careful that we don't appear punitive because our decision was ruled against.
So currently we have six conditions on the 6 proposed conditions. Are you proposing a 7th?
I'm not sure. We have to talk about what we're empowered to do. Can we? I would hope that we could at least, or is it the licensing board that sets the hours of operation? That may be. I know we've gotten involved in it before with like the laundry service on West Main Street. Concerned about the noise they were going to make at night if they stayed open all night, things like that. But and there's certainly things we, help me out here, people.
We have no ability to change the hours of the drive-through, based on their ability to be open until 1.
Oh, pardon?
That would be the only thing that would be of any consequences if the
Yeah.
hours of the drive-through, because it abutted a residential area, were, you know, as we're saying
Shut
here,
off at 8 p.m. or something.
whatever it is. I mean, it bring a good point that, you know,
If we can word that in a way that does not involve traffic generation or.
were there approved
It
hours
doesn't. I don't.
of operation already?
I don't think so. They were kind of vague about it, if I remember correctly.
It's on every other decision we make for businesses.
Looking. Give me a second.
Can I ask, Mr. Chairman,
Yep.
staff perhaps, do you recall if the previous decision had hours of operation? Or if not the decision because it was a denial, but if they stated their hours of operation? I do believe that is within the board's purview, but I don't recall what they had said their hours of operation would be.
I just remember vague assurances that, oh, we're not going to be open till 1 o'clock in the morning. Don't worry about it. But they were vague and unspecific. Just like, I could go on, but they were not specific about hours of operation.
Yeah, I mean, we didn't, because it was a denial, we didn't have conditions written in the decision.
Yeah, no, I meant more during the discussion.
Yeah.
I don't recall whether it was stated conclusively what the hours would be. I just recall them saying breakfast was not their peak hours.
Yeah. Or if there was a draft. I mean, what are you proposing for hours, sir? What would your condition be? Or Mark, to your.
Well, I'm not sure. How do you do something like that? Is it the licensing board that determines that? Or
certainly 10 p.m. is reasonable in a residential.
Yeah, 10 p.m. That's when Star Market or whatever, Shaw's closes. New England Pizza down the street closes quite a bit before that.
Was it like 8?
And yeah, 8. And I don't think it should be compared to the pizza place. What is it?
B&B.
B&B or Jack's Lounge, which are both alcohol serving establishments. So we got Star Market, the pizza place. I'm sure there's other businesses we could think of.
But to Paul's point, we should be careful that we're not putting a higher burden on them than, let's say, Dunkin' Donuts, even if they choose to close early, if they're able to stay later.
But we don't have a Dunkin' Donuts. We don't have a Dunkin' Donuts drive-through in the district. I don't think in the HB.
No, that is true.
We do. We have one on the corner in the Star Market Plaza corner there.
Yep.
There was they have a drive-through of some capacity there. I don't know I don't remember how we condition that from an operating hours perspective.
Mr. Chairman, this is Paul again, and I understand. I want to make clear that I'm not a voting member here, but I in terms of drive-through hours, I think you have to look at other locations in town that are restaurant drive-throughs, and are the drive-through hours any different than the restaurant hours? And if they're not, then I think you get a problem here if you do something different here.
I agree.
Well, I think it was a matter of, I was the one who brought that up. I think it was a matter of, what we're seeing here is that this place is looking like a drive-through only, whereas what is allowed by right is a restaurant. And so the drive-through should be a accessory to the restaurant, not the primary use of the property. That was where I was going with that the restaurant has to be open to have the drive-through, so it does not become a drive-through only situation. Because we saw the renderings and the size of the eating area is so small, but
Yep.
it still qualifies as a restaurant. But maybe it's the other way around. I don't know. Again, I'm open to ideas here.
So I'm agreeing with you, but I'm just saying that if you limit the drive-through different than the opening hours of the restaurant, I think we have to be sure that we've done that before, or we've made this a unique case.
I don't think Attorney Connolly, correct me if I'm wrong, but I don't think precedent is relevant here, is it? Every place.
I thought they were supposed to be individual.
Yeah.
Everything is considered on a case-by-case basis, but if you do impose a condition that you've never imposed on anybody else, you'd have to have a good reason for that.
It abuts a residential neighborhood.
Yeah.
Oh, I understand. These are all good points, and I totally get your concerns. I'm just looking at the limitations of the court's order. And the volume of the drive-through so far is the only thing that sounds new and different to me than the concerns that the court said you can't consider anymore. And the hours of the drive-through matching the hours of the restaurant might be acceptable, but again, it's the judge really had a limited view of what he considered substantial concerns from this drive-through.
Okay, so maybe I should make our findings and then we can work on our conditions.
Well, I have something to add regarding hours of operation relative to traffic generation. That's not the point at all at midnight. You're not going to have any kind of traffic problems at midnight, except for maybe, when bars get out or something, you might have momentary a queue of, more cars than normal. But it's more of a use and enjoyment thing of the neighbors at 1 o'clock in the morning than it is the traffic issue by far.
Correct. That's what we were leaning on that.
Yeah.
Certainly, you're going to hear that more once traffic dies down, once the noises, the background noises stop. You're just going to hear that speaker is going to go. It's going to travel. It's going to travel more in the winter than it will in the summer. It's certainly, yeah.
And remember, after a restaurant closes for the night, they're going to be making a lot of noise as they throw things out in the dumpsters and do that sort of cleaning up activity. That might be the noisiest thing they do all day, besides the cars coming in and out with their radios blaring. But
it doesn't.
And I believe we did discuss, again, I don't recall the exact, but we did discuss delivery times too. Of is there going to be an 18-wheeler in there at 2:30 in the morning, 3 in the morning, running a diesel engine and backing in and beep 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 and all that stuff.
But again, I do have to jump in because noise after a restaurant closes relates to the restaurant. It is not specific to the drive-through. So that's not something that the court would uphold.
Yeah.
Well, the drive-through hours are tied to the restaurant hours. I doubt he's going to want to have the restaurant open with its 6 chairs later than the drive-through. So I would say it's directly related to the hours of operation of the restaurant, regardless of the drive-through being open or not.
I wasn't talking about hours of operation. I was talking about discussions
Deliveries.
of truck delivery or things happening after the restaurant closes. That has nothing to do with the drive-through. So that is not something that you could consider.
Right.
And I don't.
It has to do with the hours. The hours is what I'm talking about. Hours of operation.
But we can't condition the restaurant, Herb. We can only condition the drive-through.
Right. You can only condition the drive-through, and you have to go by what you reviewed from the applicant previously. And even if you were to get the applicant's assent to something with respect to the I know when you said 150 feet, Mark, when you were talking about the noise from the drive-through, you were talking about keeping it at a certain level. My concern with that is that there was no discussion at the hearing before we closed. So you're only discussing the noise from the drive-through recording now during deliberations, but there was no evidence that you could base a decision based on the noise from the drive-through at the hearing. Once the hearing closed, your decision has to be based on everything that was discussed. And while that is something that's outside the court's order, the court didn't say you couldn't discuss that. At the same time, if there's nothing in the record, like you didn't ask the applicant any questions about how loud the drive-through intercom would be or anything like that, then that isn't likely to be upheld.
Technically, we're still deliberating, though. We would have deliberated in that moment. We often bring up things that were not brought up by the public. Sometimes there's no public comment. If we bring up something during deliberation, which is still open currently, then I believe that that is a relevant conversation.
I agree with
Understood,
you.
but you have to have something to base it on. If you deny it on something that you think is going to happen, but you didn't ask the applicant, what is your plan for this?
No, but we're not a court of law. I agree with Mark. We're entitled to bring sua sponte on our own items that weren't raised at the hearing. This is not the sort of thing where as a judicial body, if you don't raise it, you lose it. Because as Mark said, sometimes we don't have public comments. It's basically our own experience that we bring to bear.
Realistically, I'm thinking of the drive-through similar type of businesses. Realistically, the only one I can think of that is in Hyannis that even closely abuts a residential area is the Taco Bell that's down by Staples, and that is probably still a couple of 100 yards from the closest residential dwelling. This one is literally next door with the drive-through specifically pointed at the dwelling that is within 20 feet. I cannot imagine at any decibel level that drive-through speaker does not, and conversations at the window and whatnot, does not create an environment for the people living in those condominiums that especially, and I'm not talking during the day, I'm talking when they're sleeping or trying to sleep or whatever it is, that does not become a problem. I just don't see how that is.
I agree.
Yep, and I would say that goes to comfort and convenience.
So I guess, I mean, Kate, can we proceed on this? Because as you said, did not necessarily discuss those items previously, but we reopened discussions and now we're discussing them.
Well, when we had this before us previously, the traffic issues were so overwhelming that I don't think we felt the need to go into these other issues like noise, and I think light's an issue too, personally. But noise and
people who can draw blind,
and the hours of operation,
really hard to block noise out.
Pardon?
They can draw blind, but
the noises. Yeah. Yep. And for all we know, Arista is going to limit their hours anyway, but we can't really count on that. If I was them, I probably would want it open till 1 o'clock, but who knows? Not my business, luckily. But
okay, so how do we want to go forward? Or Kate, what is our options of going forward here? I mean, Manny, do you have a proposed findings you want to make?
I'm not sure I've been convinced to vote for this. I'm still listening. I'm willing to be persuaded, but I'm not on board yet, guys. And I know that this is, and I don't want to be a contrarian here, but I heard from 90 people, only one in support, by the way. And if the concerns of the ordinance is the comfort and welfare of the community, and I agree, a lot of them, Herb's right, spoke about traffic, but not everybody did. And frankly, some of the things we're talking about now, some of the fact, and I keep repeating myself, that this is directly across from a high school. That we have not volume of traffic, but who will be doing the driving?
Our deliberations were more about the traffic, but yes, I did hear definitely concerns from the people about other things.
Yeah.
Mr. Chair, if I may.
Yeah, go ahead.
To answer your question from a couple of minutes ago, the issues about light and noise are difficult to separate from the restaurant itself. And again, all that the board can consider at this point is issues related to the drive-through window itself.
Is it the- Can I clarify and ask, is it the boards, is that considered, and the speakers, is that considered part of the drive-through? We say drive-through window, but is that part of it?
Signboard. The
Signboard,
is being
speaker, window, is that considered, part one and the same from the judge's standpoint, do you think?
I would assume it's considered part of the same. The judge didn't, well, it's not the judge's role to distinguish the different parts of it, but the testimony that was provided mainly talked about the traffic and the queuing, because those were concerns of the boards. And as I said, the judge felt that the evidence from the traffic engineer that the plaintiff used was credible and based the decision on that. So the matter's already been tried. So I don't think that the judge is going to he wouldn't relook at any of these issues regarding noise and light as relate to just the drive-through window, because it's difficult to sort of separate them. And all of those issues and the almost 100 letters of opposition, all of that was brought up at the trial, and the judge was just not persuaded. One of the issues that came up previously from staff was somebody recommended perhaps we need to consider the zoning ordinance again and consider some changes, because this ordinance was changed a few years back to allow drive-throughs in the area via a special permit. So while it wouldn't have any difference on this particular case, it might set a precedent going forward.
Yeah, I think our town councilors are aware of this, and hopefully are acting on some of those ideas moving forward. So I guess I'm just not sure where we go from here. I mean,
Well, I think we should take a poll. Look, I'm willing to be convinced, to be persuaded here. Let's just poll the board members. Are folks inclined to approve this with conditions? Am I the outlier here?
No, but what do we hang our hat on as far as that window? I mean,
I don't think any of us want to approve it. I think no one wants to approve it. But we are stuck.
If I may, that was why I suggested previously, and I totally understand your objections to this. And a lot of the concerns were, is the town going to be liable? This is what you said to me at the executive session. Is the town going to be liable if a student or somebody else gets hit by a car that can't see beyond the queue, and those concerns with respect to traffic? And that's why I said that the court has given the board a very limited view of this remand, a very limited parameter in which to make the decision, and has told you can't consider all of those things that were concerns of the board previously. So issuing the special permit over objection and stating, as the staff put in the report, the report that you were all provided says that, I don't have the exact language in front of me, but maybe Anna can read us the part at the very end that says that the board continues, something to the effect of the board continues to object to this due to its traffic and other concerns related to the drive-through, but is granting it because you've been ordered to do so by the court.
Yeah, with all due respect, I think that would be more offensive to the judge than what he wrote. He did not order us to issue the special permit. We saying that we think the judge has ordered us, that actually, I think, will upset him. I think he told us what we can't consider.
You're right.
I agree. If the drive-through, even the words speak it, right? If you can't consider traffic in relation to a drive-through, does that not occupy the entire field, so we don't really have anything to object and base our denial on? I get your point. I get that. I hear that. But I also think that this ordinance, the way it's written, require us to do more than look at your standard special permit. It talks to things of comfort and convenience of the community. And I was really persuaded by some of what I heard beyond traffic. So, but like I said, I'm willing to hear.
Understood, and I agree with you. The judge didn't say you have to grant it, but he also said reconsider it. And most judges on remand, pretty much all of them, they're not going to issue the permit. It happens once in a while where the judge actually says the board got it wrong and they issue the permit. But most judges remanded to let you do the issuing. But in this case, it was
Well,
a very
that's why I
limited.
disagree with item 5 on the conditions, because it does say that. It says the board finds that the land court has ordered the town of Barnstable to grant the special permit. I don't think that's gonna sit very well with this judge.
No, I agree with that. That one could be reworded to be a little bit more accurate with respect to the order, because you're right, the order doesn't say you have to grant it. The judge would not do that. The judge remanded it for the board to reconsider, but then said you cannot consider any of these things and listed all of those items that were of concern to the board in paragraph 3.
But he didn't say we couldn't consider anything new, like amongst ourselves, correct?
If it was something that you had, that was discussed at the hearing and that the applicant provided, you know, plans that addressed certain topics or failed to address them. But again, it would still have to relate directly to just the drive-through window and the things that go along with the drive-through window, but not things related just to the restaurant.
The traffic did dominate the conversation, and I think there were so many people speaking. We did not even get to the point where we were speaking about noise of the speaker and the things like that. I mean, it's only given a few moments to step back that, you know, that is, you know, now that we look at it, common sense would tell us the potential late hours of that drive-through window are going to be a complete nuisance sound-wise to, you know, abutting tenants. And I don't think it's unreasonable to consider that point.
I mean, the neighboring building is like what, maybe 10 feet from the property line?
Maybe.
The residential, if even that.
Probably 10 feet.
So again, this is Paul, and I'm not part of this, but I relate to Manny. And so what happens if comfort and whatever Manny said, we vote, or the vote is no. So go back to the judge. I mean, what are you risking? Are they going to fine you, or is he going to just make another order?
Kate, I'll defer to you on that.
If you vote not to issue it and don't have good reasons for that, that would not sit well with the judge, because he already found that the concerns of the town, and we made the point that the things the neighbors were complaining about, while valid for the neighbors, weren't things related just to the drive-through, because a lot of the complaints the neighbors had to do with things that related to the restaurant. And we made the point that, or tried to make the point, that the board was not persuaded by those things. The board was concerned about the traffic and the queuing, pedestrian and vehicular traffic. So while the court remanded it to let the board make the decision, again, it was very limited in what you could deny it on. So you would have to have a very good reason to deny it, given the court's position.
So I guess, Manny, I'm going to turn it back to you. Do you feel you can present a strong argument that there, you know, that we can all stand on, that's related specifically to the drive-through and doesn't touch anything on traffic or pedestrian?
I think you've added to some that I raised. I mean, I think the sound is unique to the drive-through, right? I mean, people are talking from inside, communicating to somebody outside in the car. That's volume that's going to be the decibel level is going to impact the convenience and comfort of neighbors. I mean, that's unique to a drive-through. If you were just going into a restaurant, you don't have that dynamic, right?
And that the
yelling across a window.
And that it abuts residential. The drive-through is literally up against residential. I don't think, you know, that's sort of not that common.
It's certainly the speaker. It's not, you know, it's the noise from the speaker. General conversation, you would be hard pressed to hear that from a house. You just wouldn't. I don't think it's enough to hang our hat on. I think if the speaker is something that people are going to be able to hear when there is less environmental noise, traffic is slowed, especially late hours, I think that's certainly speaks more to Manny's point.
And,
If I may.
I mean, I guess people can put curtains up, but the LED sign I think would be very bright for the people living on the second floor of that condo building when it's right outside their window. Go ahead, Herb.
Yeah, I don't see denying this thing outright, but we do need to put some conditions on it. And any condition we put on the restaurant as a whole includes the drive-through. Because the drive-through is the main purpose. There's 6 chairs, not 6 tables, 6 chairs in the restaurant. I've never been in a Wendy's that has 6 chairs, but
They put 2. It doesn't matter.
yeah, but it's not 20, and it's not. So I think we need to just treat. I don't think we can say that noise from deliveries are not related to the hours of operation of the drive-through, because I think for all intents and purposes, for the purpose of discussion, the hours of the drive-through are going to be the same. It's on one of our suggested conditions, number 5, I think it was. Whoops. The hours of operation of the drive-through shall be the same as the hours of operation of the indoor restaurant. So
Herb, the intent there was that the restaurant stays open while the drive-thru is open. So there's bathroom access, there's, things of that nature, that this thing isn't just a drive-thru only and people are just, because a restaurant is required there, but we give them
I don't see the restaurant with its 6 chairs being open till 1 o'clock while the drive-through closes at 10. So
are you proposing to condition the closing of the drive-thru at 10 p.m.? We can't condition the restaurant.
That'd be a good start. And if you don't think we can get restrictions on any kind of deliveries or anything like that, fine. But I think we need to at least limit the hours of operation of, okay, we'll call it the drive-through, but I doubt they'll keep the restaurant open later anyway. But I would definitely be 10 o'clock. I don't think there's anything we want to do in the morning.
Traffic starts early.
Yeah, does it?
Yeah.
Yeah, people are probably pulling in there at 6 o'clock in the morning.
Noise ordinance is 7 anyway.
breakfast.
So.
Pardon?
Noise ordinance is 7 anyway, or not noise ordinance, but any type of.
Yeah.
They can open when they want if people are up.
Common decency. Yeah.
Yeah, but again, to your point, Mark, like what time's that speaker going to start squawking away for the people sleeping in those 4 condo units right literally on the other side of the fence?
I mean, I only know in construction you can't start hammering away on things until 7 a.m.
Because there is no other early morning drive-through close by, so people may go there for their breakfast and their coffee and such.
Well, certainly the school is in. They start quite early at the schools, so I mean that means that they're going to go early enough to, to have the kids be able to drive through there and then go to school. I think school's in by 7:30 at the high school. I could be wrong, but it's early.
Okay, so again, I'm just not sure where we go with this. Like, are we working through the findings as written in the staff report, or Manny, do you have proposed findings? Because no matter what,
is it? I know they asked, and perhaps this is not allowed. Maybe this is for attorney. Can the applicant weigh in on any? Are there things that maybe there's a common ground here? We're talking about limiting the hours of operations of the drive-through. Is that something that's palatable to the applicant? Can we get their input?
If I may, because public comment is closed, the applicant can't weigh in at this point. But I can talk with the applicant's attorney about certain questions that you may have about certain conditions that you may want to impose. But you would have to continue tonight.
Is that going to be a problem with the judge?
Well, the judge said to commence within 45 days, and obviously.
Oh, so we commenced. Okay. All right.
Yeah. So we wanted to get on it as soon as possible, not drag this out. But we've done that because we put it on for the first meeting that would meet the posting.
I think the noise is enough of a concern that we could at least broach it with the applicant and, see if there's a reasonable nighttime out. We don't know if there's children, in this unit next door or within, 100 feet. It would be maddening, to have that thing going all the time, especially if you're trying to sleep. I mean, I can't imagine this isn't something reasonably we can bring up.
We've also conditioned fences around noise emitting things, like even a cell phone tower. Everybody probably remembers that we required a fence be put up so the noise didn't bother the neighbors, the humming noise or whatever. So we might want to think about a fence behind it.
I mean, essentially, we could probably condition it that there is no speaker and that the orders have to be made at a window with a human. If we really wanted to.
That's true. That would kind of.
Yeah, I like that.
So they have to go up to the window, order, wait for the food.
I like that.
So are we talking about continuing this now, or as we?
What's your?
We have to add the condition first.
Yeah, and I want to remind you got to be careful about, you can't completely reconfigure the project. I just heard something about taking the drive-through, taking the speaker away. I mean, if that was part of what they proposed and this wasn't discussed and you didn't give them an opportunity to redesign it, I don't think you can raise that at this point after the trial.
I would be at 10 p.m., close the window.
Yeah, hours for the window is something that you could talk about.
I think that's a reasonable hour. That's about as late as you can go before it,
Jim, did you have a point you want to make?
Yeah, thank you, Chairman. If we are continuing, this matter, and Attorney Conley may be talking to the applicant's attorney about conditions, perhaps a condition related to light and noise could be something to the effect of all light and noise related to the drive-through operations shall not trespass onto abutting properties due to the proximity of residential next to the drive-through, and perhaps something about the applicant shall mitigate any light or noise that may trespass as proposed.
And I would ask if you're going to put together some conditions that you give them to me in writing so that I can share them. And again, you got to keep it to things that you discussed when the applicant was doing the presentation. And remember that the judge, while I agree with Manny, the judge didn't say you have to grant it. He very much limited what you're allowed to consider on this continuation of deliberations, which is what the remand is, and found that there was substantial evidence supporting the testimony of the traffic engineer. So the judge found that individual was credible, and that's why he ruled out all of the issues with respect to traffic. So if you come up with other things, such as the hours of operation, you need to have substantial evidence to support why those are required so that you don't derogate from the intent of the bylaw or, cause a detrimental effect to the neighborhood.
Okay, so is the desire of the board to continue this? And Kate and Jim, do you feel comfortable with us making that decision? Is that acceptable?
When is the next hearing that you could get it on for?
May 12th in person.
May.
I mean, sorry, March.
Yeah.
Sorry.
Oh, I was going to say.
Sorry, March. I'm sorry.
I don't, I hate to do this, but I may have a conflict on the 12th, as I mentioned earlier. So, I think if, and I think I've taken an informal poll in my own head here. If the intent of this group is to approve this and impose conditions, maybe we should try and plow through, because I'm afraid I may not be able to make it on the 12th. And I know we're down to 4 already.
So, Attorney Conley, if we impose the condition of limited hours, let's say 10 p.m. as an example, does that then go to appeal? What happens at that point?
No, there's no further appeal of we've already had the trial. The judge issued his decision. So
Right, I
we go
understand.
back with the new, whatever the decision is, presumably a grant with conditions. And then the judge, he retained jurisdiction, meaning he'll review the decision and determine if it's reasonable.
I guess what I meant is if the judge looks at that and says, nope, unreasonable, they should be able to have whatever hours they want.
Oh, okay. So yeah, that's not directly an appeal, but that's what you meant by appeal.
I'm sorry.
The judge would order us, if he disagreed with it, the judge would give us a further order of what the board needs to do.
So if we said that number 7 is that, that the applicant shall limit the hours of the window from X morning, whatever that is, to, or it's more the late one, to 10 p.m. at night, and they want to push back, based on the proximity. It's an outlier, so however we might want to word that the unusual proximity to residential, or not unusual, but it's one of the only ones I can think of in town that actually directly abuts. It is certainly an outlier, and we use that as the condition or the reasoning for conditioning.
Sounds
It is
reasonable to me.
unfortunate that public comment is closed. I mean, the whole case is really closed, but if we could have had public comment, I'm sure the public would have things besides traffic to weigh in on.
Well, because again, if it was the restaurant's there by right, you're not going to hear conversations if you're not going to hear a speaker, you're not going to hear anything like that if it's just the restaurant. But if we're talking the addition of a drive-through window, that directly is going to affect the how the neighbors are perceiving the business as far as actual interaction with the business, as far as the sound coming in at certain hours. I think 10 p.m. is reasonable, especially considering where that is and the proximity. So I think
Mark, could a compromise be no speaker beyond 10? If for whatever reason they want to go beyond 10, it's window, no amplified sound, just voice to voice.
I don't see there's a problem.
I think we just say no drive-through though, because I still think there's going to be other noise, diesel trucks and other things right there. I mean, looking at the site plan, the drive-through is the speaker is on the West Main side. It's not around the corner, so you're not going to have the speaker noise blasting at the residential. But still just like the noise of idling cars is a noise, and headlights beaming around corners, it just happens.
But that's traffic.
But
right.
That's not an issue that you can consider, because that relates to the traffic queuing, all of the things that the judge said you can't consider. So
I would say if we'd approved this before, we would have had conditions about hours. If we'd come up with our own traffic study that agreed with theirs, and we're going to be putting traffic controls in at that intersection in the future. I think if all those things had been considered but somehow we had ruled in favor of the drive-through last year, I think we would have been discussing other things like the hours of operation a lot more closely.
At this point, it's more of an ask, right? I mean, it's just a courtesy. They know how the public feels about it. There's obviously an upper hand in this situation. Not happy about it. We're not happy about it as a board. I don't think there's anybody in here in favor of it. And, at this point, asking people to be reasonable. They are very close, residential properties to this, to this operation. And if we put it in a condition, they want to push back, we can't stop them from doing that. It's their right. But I certainly think we could at least ask for the condition.
Okay, so Manny, I'm going to defer to you again. How do we go forward?
Thank you, Mr. Chairman.
You wanted to push through, so I just want to know the direction you want to push through.
I'm hearing that, and tell me if I'm wrong, that the sense of the board is to approve this and add conditions. I am okay, I'm okay with the conditions that seeks to limit the hour of operations or alternatively, the use of amplified sound. I think you can deal with light from headlights and so on with a fence.
Sure.
That can be mitigated, but I think the noise is harder to abate. So if a condition that either limits the hour of operations till 10 or the use of amplified sound on the speaker after 10 sounds reasonable.
Yep.
And I think you'd have to be careful with things like a fence for headlights. To me, that's bordering on traffic.
Yeah.
And things that are just completely new.
Yeah. No, I'm not saying put that as a condition. I do think, wasn't there, I don't have the plan in front of me, wasn't there some sort of fencing on that side as you come around the drive-through? I thought there was. In the plan itself.
Just closed it.
When we approved the, what is it, Domino's on Route 28 across from the mall, we specified fencing around that because of the abutters. So I don't, and it didn't have anything to do with traffic. It just was out of consideration for the abutters. I don't see how that would be a problem requiring a fence.
A fence where though?
Directly along the property line.
At the drive-through or someplace else on the property?
Between the residential and the drive-through.
Yeah.
Jim, go ahead.
Mr. Chairman, there is a fence there. It's
that's what I thought.
There's an existing stockade fence there.
Yes.
You know,
That's what I thought.
Well, we should at least say that the existing fence shall remain unless it's on the other property. Or not.
So Jake, I'm not willing to make findings here, but I would say this: whoever's making findings, we need to change number 5 because I think that has most likelihood of pissing off this judge if we're telling him that we feel like he's ordering us to issue this.
Well, he is.
I don't disagree with you, Herb, but I think if we told him,
remember the definition of remand was. The root word is mand, as in mandate. So he's mandating that we approve this.
I don't think that he would take kindly to us saying that because I do, even if it's just words.
If I may, Mr. Chair, yeah, to Manny's point, I do understand, and you're correct. As a former attorney, I know you're aware that the judge, he didn't, and I know I've said this, I don't want to be repeating myself. He didn't order you to grant it, but he ordered it remanded and limited what you're allowed to consider. But that's perfectly fine if you change the wording of that paragraph so that it doesn't say ordered you to grant it. Just say ordered a remand, limiting what you could consider or something like that.
Okay. So I guess I'll make findings in special permit number 2023-010 remanded.
I have one more question.
Yep.
Can we find some other word to express our approval other than I just can't say I'm in favor, though I can't use those words. So do we have other words that we can use?
You just say you're granting your a yes vote under protest.
Yep. Oh yeah.
No protest. I like that.
Yep. Not just protest. Utter protest.
Okay, I'm going to go
That was
through
what I suggested at the remand hearing, that if, that again, I was saying you're not going to be held liable. The board was asking me questions about whether you could be held liable if somebody gets injured. And I said that I totally get that that's a concern, but the judge has ordered that you not consider traffic. So you could say, if it makes you feel better, in granting it, you grant it under protest or grant it over your objection or something to that effect.
I'm also concerned about these 90 plus people despising us as a group, but we run that risk every session. So
I think we've explained our positions here. I think anybody who's concerned is watching, and I think they know where our position is on this. They can come back and watch it if they want.
Yep.
So I'll just read the background in making findings here. The subject property is a 0.45 acre developed lot with frontage on Pine Street and West Main Street in Hyannis. The property is developed with an approximately 3,123 square foot commercial building previously containing a bank. There is an existing drive-through window with 2 lanes located on the westerly side of the building. The area is both multi-unit residential and commercial, with the Barnstable High School directly across the street. On April 6, 2023, Arista Hyannis LLC applied for a special permit in accordance with Section 24025B22 and 24025C10 drive-through for a proposed restaurant. The applicant proposed to remodel the former bank building and change the use to a food service establishment, Wendy's, with a drive-through. The application was continued May 10, 2023, July 26, 2023, September 13, 2023, and October 11, 2023, November 8, 2023, January 10, 2024, and to January 24, 2024, at which time the board deliberated. We listened to our 97 public comments and determined that we were going to deny the application and denied the application on the merits based around the traffic and the reasonability of this drive-through fitting into this neighborhood. On January 28, 2025, the land court judge filed a judgment in favor of Arista Hyannis LLC and against the Zoning Board of Appeals and remanded it back to the town. According to the judgment, the board may not consider the impacts of Arista's proposed drive-through on a traffic generation, the circulation of traffic within 715 Main Street, including but not limited to the amount of queuing within the site. We cannot consider parking within the site and or pedestrian or vehicular traffic on or along West Main Street, Pine Street, or the intersections of those streets. For our findings, we're required to make general findings pursuant to Section 24125C. The board's reviewed the evidence presented, the limitations that have been constrained to us.
And Jake, sorry to interrupt, but I think we need to make a finding pursuant to 24025.
Yes. So the application falls within a category specifically accepted in the ordinance for a grant of a special permit. Section 24025B22 and 24025C10 drive-through for a proposed restaurant allows for a special permit. Site plan's been reviewed and found approvable in accordance with Section 9 herein, subject only to the issuance of the special permit. There was a letter from the building commissioner dated April 11, 2023. The land court orders, judges and decrees that without limiting the foregoing numbered orders, the board on remand may not consider the impacts of Arista's proposed drive-through on traffic generation, circulation, and traffic within 715 Main Street, including but not limited to the amount of queuing within the site, parking within the site, and or pedestrian vehicular traffic on or along West Main Street, Pine Street, or the intersection. The board continues to find that after an evaluation of the evidence presented, not including the traffic, the proposal would represent a substantial detriment to the public good of the neighborhood affected due to the requested drive-through. The board disagreed with the court's findings and continues to raise concerns over the traffic volume, turning movements, parking impacts, and how each interact with the neighborhood and its unique location given to its proximity to the high school campus, the intersection, and the transit of West Main Street in Hyannis. The board finds that because of the land court's order not to consider the traffic, that the town of Barnstable Zoning Board of Appeals will grant this permit on remand. Those are my findings. Herb is second. Kate, is that acceptable?
Yeah, that sounded fine to me.
Okay. We have a first and a second, so it's a roll call vote to approve 2020 special permit number 2023-010 on remand based on what the judge has ordered us to consider in making this decision. Herb Bodenseek.
Granted under protest.
Mark Hansen.
Granted under protest.
Manny Alves.
Reluctantly granting it under protest as well.
and I am also granting it under protest. So now we need to decide on our conditions on special permit 2023-010 on remand. The draft conditions currently are stating that special permit number 2023 is granted in accordance with section 240 for the proposed restaurant. The site development would be in conformance with the plan, Wendy's redevelopment that was presented to us, dated December 5th, 2022, and then revised March 30th, 2023. And then this would be a full build out of the lot. All the mechanical equipment, air conditioners, electric generators shall be screened from neighboring homes and the public right of way. The hours of the operation, what was discussed, and I guess what I will propose is the hours of the drive-through operation shall be from 8 a.m. to 10 p.m. and the restaurant will be open while the drive-through is open.
I think eight may be too, they may want earlier.
I agree. They're going to try to catch
not morning.
Yeah. Yeah.
So I don't know what they proposed. I don't know if anybody remembers. But I think they may want to open earlier than that to catch the kids before they go to school.
Can anybody check hours on their current Wendy's?
I thought they told us hours. I'd have to look at the minutes, but I feel like they gave us hours that they were proposing to be open. And they also stated that they wouldn't open until the new light was put in at the intersection.
They're open at 6:30.
6:30 to 1 a.m. is while the current Hyannis Wendy's is open.
Then I would propose 6:30 to 10, hard 10.
Yep.
But in how Manny was saying it, it closed or the
restaurant can stay open.
Restaurant can stay open, but no amplified, either closed by 10 or no amplified sound at that point. Beyond that point.
Okay.
On the board, on the drive-through board, you know what I mean?
Correct.
Yes.
Yep.
So
and then,
are the hours contingent on the licensing board approval, or is that completely on us?
I mean, we're just, Jim, can you answer to that? I think we're just conditioning the drive-through operational hours.
Right. You're currently right now can condition the drive-through operation hours. They can subsequently speak with licensing, but they still have to adhere to your
But they can
decision.
modify it too if they don't like our suggestion or condition.
They could, but they still have to adhere to your decision if this is upheld.
And again, I think as Mark put it, it's not up or down. If they choose to stay open until an hour that is permitted under whatever licensing board authority, that they do not use amplified sound on the order board. I think that sounds reasonable.
A little complicated though.
Well, then we just say 10 o'clock.
Yeah.
I think you just say 10 o'clock. I think it's just 6:30 to 10 o'clock. The restaurant can stay open till, I think, whatever the licensing board says, but like all night for all we're concerned. We don't have purview on that.
Right. It's only the drive-through.
Yeah.
Okay.
And then do we want to add what Jim suggested, which I can't say as eloquently as he read it, that light and sound does not trespass off the property and mitigations are made to try to limit any sound and light from
specifically related to the
drive-through.
Drive-through.
Yes.
Yeah, I think that's fair. That they'll take reasonable efforts to mitigate all noise and light pollution. After, I wouldn't even, since we're putting a 10 o'clock drop hour on it, that they'll take reasonable efforts to mitigate noise and light and other pollution, by the way, because people can drop things out of their car. That's part of the drive-through. It's not a restaurant, right? People can just take their bag and dump it, and it ends up in the neighbor's yard. So that they'll take, reasonable efforts to mitigate and eliminate pollution. that what you said, Jim? Sorry, you said it a lot more eloquently.
Yeah, I don't know that you can go that far to talk about trash and things like that, because that was an issue at trial. That's part of a restaurant. That's not just part of a drive-through.
Right.
Well, okay. Yeah, I think it's, I hear you.
It definitely, when it goes in a drive-through, it will definitely be on the side of the road going down
Exactly.
Pine Street more than it would if there was no drive-through.
Yeah.
I just don't think that's something that the judge is going to think.
All we're asking is reasonable efforts. Even if it's from a restaurant, they ought to be taking reasonable efforts to be good neighbors and eliminate pollution. I don't think that's unreasonable.
Well, I thought that was pretty eloquent, Manny, really. Yeah.
So do we have that sort of drafted? Anna or Jim, can you sort of reiterate what we're voting on there?
Yeah, so the hours of operation of the drive-through shall be the same as the hours of operation of the indoor, and at no time shall hours of operation extend beyond 10 p.m. And all light and noise related to the drive-through shall not trespass beyond the property line, and reasonable mitigation shall be made to limit all light and noise to the property line.
From the drive-through, right?
From the drive-through, yes.
And specifically call out the drive-through on the 10 p.m. because it sounds like we're saying shut it,
Yeah, the restaurant can stay open later. The drive-through has to close at 10.
Yep.
Okay, so I think we're good to vote on the conditions as discussed and drafted.
Well, and number 6 too, that decision shall be recorded.
Yes. Yes. Yeah, as written in the staff report, dated February 25th, 2025, and as amended in this meeting. Roll call vote. Herb Bodenseek.
I'm down. How's that?
You're down?
Or granted under protest. I'm down,
Mark Hansen.
Yes, again, granted under protest. Thank you.
Manny Alves.
The same. Reluctant and under protest.
And I also am the same, reluctantly granting under protest. But I think we've made
Folks, thank you for sticking through this. I'm sorry, but my schedule on the 12th is going to be problematic.
So, Manny, you were really important in this.
Yeah.
Thank you.
Well, I really, like I said, if this is to protect the community, as the way that our ordinance is written, it ought to be looked at, because we heard from the community, folks.
We've already been talking.
And I think I've heard Councilor Ludke talking about it. There's been a lot of discussion about West Main Street as a corridor, and this is part of it that needs to be addressed.
Yeah.
So I hope that it will get discussed soon, and I don't think we're necessarily in the position to ask planning to draft revisions. We're the appeals board. I think, we can send a memo to the planning board potentially to really to move this along. But I think it also faster comes from a counselor.
Yeah,
and I think Councilor Ludke's district, part of it is.
It did come up last night, last night at LCPC as well. So that was also a discussion that was being had about potentially, down zoning that area to something a little, or changing something about the drive-through. But certainly there's a conversation being had.
Yep. All right, so we had correspondence, Cape Cod Commission meeting notice for Eastham DCPC Thursday, February 27th, 2025 at 3 p.m. Cape Cod Commission meeting notice from Wilkins Housing Phase 2 is Thursday, February 27th, 2025 at 3 p.m. Cape Cod Commission meeting notice for Wilkins Housing Phase 2. There was a meeting Wednesday, February 19th, 2025 at 5 p.m. Park City Wind LLC, final order of construction of the substation. Cape Cod Commission meeting notice for Wilkins Housing Phase 2. Another meeting Monday, February 25th, 2025 at 5 p.m. And a Cape Cod Commission DRI decision for Straightway and Hyannisport water facilities. Any matters not anticipated prior to the meeting? Upcoming hearings, March 12th, 2025 in person. It sounds like we may have a limited of who's going to be there. And maybe in not too much time, send an email to just poll the group to make sure we don't need to cancel that. What do we have on the docket. Is there much on there? We've got the holistic McNamara.
And the problems with the 12th were that people who had been on former cases, not so much attendance itself.
Well, we don't have Paul, we don't have Manny, we don't have Aaron. So I don't know if Natalie's back. Rodney, will you be here around on the 12th?
I'll be around on the 12th.
Okay, and Larry, you'll be around for in-person on the 12th?
Yes.
And Mark, you will be?
Yeah, I'm just looking at a calendar. I'm here.
So if we have the 4 of us and we add Natalie, we have 5 and we have a quorum.
Excellent.
Right now, we have 4 items on the agenda.
Okay. And Herb, I didn't ask you, you're around on the 12th?
Yes, I am.
Okay, so we'd be okay. We would have 6.
Okay. Good.
All right. And then we've got March 26th, 2025 remote, April 9th, 2025 in person. I'll make a motion to adjourn. Do I have a second?
Second.
Roll call vote. Herb Bodenseek.
In favor.
Paul Bernard.
Favor.
Mark Hansen.
In favor.
Larry Hurwitz.
In favor.
Manny Alves.
In favor.
And Rodney Tavano.
In favor.
And I'm also in favor. So we are adjourned.